All right. Hey, everyone. Welcome to sort of the Bitcoin lore review. Man, I'm always starting my shows off in the same exact way. And I forgot because this show has not happened in a super long time. Oh, shit. Where the hell is that coming from? To always screw that up. Here we go. The last time we did this, I think, was when we were all together in Miami. I think that was in January. I don't think we got together during Bitcoin 2022. Mr. William Restus, Bill Restus, was not there with us. So thanks for coming back to the show. And we, of course, have Jason Seibert, the usual member of the show. This is, as you guys know, this is one of my favorite shows because I let the experts speak. And sometimes I give my own comments that they laugh over. But I've gotten to know the law pretty well, especially in the crypto space, thanks to these fine gentlemen. And I use those words very loosely. So on that note, I'm going to let you guys introduce yourselves. Bill, let's start with you. You weren't on the show last time. So Jason will go second.
Hey, everybody. Bill Restus. There we go. It's been a while since I've done a podcast, so I got to get used to this "don't talk over people" thing, so that's enjoyable for everybody listening. Bill Restus. I have the Restus Law Firm in San Diego, California. I've done several class actions in the crypto space. There was one against Coinbase. I have 3 now against various ICOs, and now with a lot of the problems that we've been having in DeFi and protocol failure, there's a lot of losses out there. So one of the things I want to talk about today is where I think a lot of the crypto class action litigation is going to go in the next year, because I'm working on some projects right now.
All right. Thank you, Bill. You've been a long-term member.
Yeah, and I don't have a Twitter because I generally don't like publicity. I'm sort of don't find me, I'll find you kind of a person.
All right, Jason, your turn. I love that picture. That is the very first episode of the Bitcoin lore review. It is, one of these days I'm going to release it. I have the video. This was me hosting the law panel in 2016, I think, maybe even 15, in the bathroom of the Miami TNABC conference, which is actually one of the scammiest conferences ever, because all they do is just anyway, like the conference isn't scammy, but like all the people that like launch their projects there are from Ethereum to BitShares to the rest. So we love that conference to attend it, and that law panel was awesome.
I'm pretty sure that was 2015, Tone, because shortly after that, I started my Not Your Lawyer Show podcast on Exotica.tv, and was publishing at the same time that Bitcoin Uncensored with Joseph and DeRose was on, and I met them at the conference, and they were hosting Bitcoin Uncensored in the bathroom at the conference center, and they stepped out, and that's when we did the law panel. That was it was a lot of fun. A lot of things have happened since then in the cryptocurrency space, especially the not resurgence but surgence of DeFi type products, which we're going to be talking about today, obviously, with 3CA Voyager and Celsius, and sort of the structure of those and what's going on within those protocols. Most of the folks on your podcast on the law review know me. Most of them hate me. I don't give red meat. I just kind of call it how it is. Sometimes I'm right, sometimes I'm wrong. But regardless of the result, I try not to take sides. Instead, just try to bring the truth as according to the law as it stands today. So thanks again for having me on. So Bill, good to see you. And I understand we're going to have David a little bit later on, and Simon Dixon's going to be joining us as well. So
yep, David Silver and Simon Dixon will join. All right, let's just get right into the stories. We have 2 hours max from these gentlemen. We'll see how long Simon sticks around, but and David. So let's jump into the stories. We're gonna start. I'm not sure what David's which one David wants to talk about, but we're going to stick to this order. A new case just broke. There was a class action lawsuit against Solana, and the class action lawsuit claims that Solana is a security. So let me read real quick. And all these links are in the video description, guys. I just poured myself a glass of tequila, but I don't know if I can be drinking that for the entire 2 hours. So this should be fun. I'm enjoying my time in the woods. So nice and refreshing. All right. Plaintiff Mark Young, a resident of California, alleges that defendants violated Section 512A, whatever, and some other section of the Security Act and more sections of the California Corporations Code. Plaintiff claims are based on defendants' sale of Solana securities without any registration statements in effect and their promotion of unregistered Solana securities. Plaintiff claims are brought as a class action on behalf of himself and as a representative of proposed class. Well, anyway, you guys get the point. Basically, Solana is a corporation. I have always said this going back as far as Ethereum. I should have grabbed that YouTube stream where Jason and I explained the high probability of Ethereum being a security. And that video is from early 2017, if not 2016. That was part of my crypto scam series as to why Ethereum and all similar things, including Solana, are very likely to be violation of securities law. Solana is basically, to me, in my personal opinion, is a centralized company, no different than Microsoft, creating a database for people to use. That database happens to have their own Solana token, which is used as a quasi-currency, quasi-utility, and high probability of potentially being a security. So here's the class action. Of course, when the price of these tokens go down, all the class action lawsuits come out. So I think this is, it's hard for me to use the word good, but it is in line of my views on the Solana token, and hopefully the class action law firm bringing this case has let's say, better arguments and lawyers than the SEC versus Ripple, which we will get to later, and they could actually get something done. Because if it smells like a security and it looks like a security and it acts like a security, it is probably a centralized security. Now, I'm going to leave it up to these guys. I don't know who wants to go first. Raise your hand or just
this one's kind of in my wheelhouse here. So what you're reading, Tone, is something called a notice. When you file a securities class action, in most circumstances, you have to give everybody out there who could be a plaintiff the opportunity to come in and tell the court that they want to take control of the case. Okay, so that's what this is. This is notifying the public that you can hire your own lawyer and you can go and tell the court why your losses are bigger than someone else's losses and why you should be appointed to lead and control the case. It's usually a big fight between the big class action firms who all try to fight over who has the biggest plaintiff and can get control of the case. Now, this particular case, I mean, obviously, we've been talking about the issue of whether token X or token Y is a security, going back to you guys were earlier than me, but we were talking about it in 2017. I'd launched and was part of the lead counsel team on the Tezos litigation. This one is, while the kind of concept of whether any particular token is a security or not is pretty well worn, this case, I think, has a lot of issues. And I took a look at it earlier, and if you're going to bring a claim saying that you didn't have a registration statement and you want to rescind your investment into an ICO, it has to be within a year of the offering. Okay, so their ICO, and I don't remember exactly when it occurred, was more than a year in the past. Now, how are they getting around that? They're basically saying that it was a continuous offering because Solana Labs or one of the other defendants or more of the defendants are basically taking their tokens and selling them on the secondary market. Okay. When you get into a class,
it was March 24, 2020. It's
okay. So still, it's more than a year, and that's
wow. One day after the big crash from COVID, literally in the depths of the shutdown. Yeah.
Right. So
People
you know,
were a little preoccupied.
they might have been, but they should have brought it if they really wanted to have the best case here, you know, before March 24th, 2021. Now, obviously, they're about a year late. So what they're saying is that you need to account for all of the sales of the Solana Labs or any of the individual defendants on secondary exchanges. And that was sort of like an IPO. The problem with that is you need to have, if you're going to have an unregistered sale of a security claim, you need to have privity with the selling party. Okay, and that's really easy to establish if you are, privity means you're directly interacting with them and you're not buying on the secondary market. And that's really kind of easy to establish if you have just one person and you know where you're buying it, or if you buy it directly through an ICO. But in this case, if you buy it on the secondary market, you know, if let's say Solana is selling on Binance, but not on Coinbase, I'm just using an example, you would only be able to have privity with potentially the people who bought it on Coinbase, right? So there's a lot going on here. I actually don't think this case is going to be very successful. And I can be verbose, so I'll just stop talking about those details and let everybody else chime in.
So real quick, Jason, real quick on that. So, but Bill, I actually didn't know that. I didn't know you're supposed to bring these things within a year, right? Because to me, Ethereum is still a freaking security, and I'm still like, again, I hate to use the word hoping that someone will do something about it, but in a way, I kind of don't, because the SEC does more harm than good. But this is a huge loophole. None of these tokens lose money in the first year, especially the ones being pumped by VCs. So there was no way in hell anyone was going to bring the Solana case, because this thing would pump for years before people realize how useless the token is.
Right, and you need damages, right? So there's
exactly
right.
Actually, hold on. Let's distinguish this. The private right of action that's expressly given under Section 12 of the Securities Act has that limitation of 1 year. That limitation is not imposed upon the SEC to bring an action later. It's only for individuals that want to bring that private right of action. So that this doesn't preclude a regulatory agency from still doing something, Tone. I just wanted to make sure that distinction was there.
And it doesn't, and this is sort of another thing that I want to get to today is right now we're in a situation.
Hold on, Bill. I just remembered one of the things that you said, that there need to be damages. In a rescission case, there doesn't have to be damages.
That's true, but
all you're asking for is the return of my original investment price. And this was the big argument in the Tezzy's case, was whether or not we crossed over the Mendoza line, right? If it was more favorable economically for people to rescind and get their original Bitcoin purchase price back, or based on the price of Tezos at the time, if it was more advantageous to hold on to your Tezzies. So you've got these economical decisions of whether or not you want to elect the rescission option that the Solana folks here are pushing for, or if you say, screw it, I don't want to rescind, I want to move forward, right?
Right. That's a big issue, obviously, in these cases, because generally in a US court, the judges like to deal with US dollars, and they like to give a judgment for you in dollars. And if you start to say, well, I want it in Bitcoin, or I want my ETH back, and there's a conversion price, that tends to get really difficult for a judge to understand. And particularly for the lawyers that bring these cases, because they're so expensive and such a big undertaking. If the tokens sold in the ICO or given in the ICO, and I'm using that word broadly because nobody says it anymore, but I understand that. If those are up, and nobody's going to want to bring a case and make that economic investment on the off chance that the token might take a crap.
So colloquially speaking, we call that the good deal exception to registration.
That's right.
Is that nobody wants to file a claim when they're making money. The claims start flying in when it's a bad deal. And
on that note, right on that statement, this is our moment of Zen. I always play this little 40-second clip at the end of our shows. God, I hope this never leaves YouTube, but someone is going to download this for me and send it to me. I'm sure it's been done before. This is an old tweet. It's in the links at the bottom of the description as notable mentions. This is part of a tweet storm of me getting a cease and desist letter from the Token Pay scam. And this is the CEO of Token Pay. So please listen to this moment of Zen. And I'm going to take my microphone. I'm going to put it next to the speaker so you guys can all hear.
Got questions?
Yeah, I had a question. I appreciate you guys making this happen and you being here, Derek. But the question I had, I've been going through ICOs and researching a little bit. And how safe are we here in the U.S. Not being an accredited investor investing in this ICO?
How safe as you or for us?
For myself.
You guys are fine. I think one thing I've learned a lot in the industry, especially since working in the finances, as long as the people make money, nobody complains.
I rest my case on the good deal exception. There it is, which is not a real thing, by the way. Don't rely on that as legal advice.
All right. So I don't think there's
Don't put your microphone back by your shirt there.
Oh.
So where I was going to go, just a real short segue into some things I'd like to talk about today is, we've got a lot of decisions out now in the courts that these token issuance events are, and in some contexts, the tokens themselves or the DEXs themselves can be securities, right? So I think where we're going to start to go is from this failure to register your token as a security to using the anti-fraud provisions of the securities laws, which is, wash trading. There's something about pegging something to be a stable coin. That's a violation of Section 9. There's false and misleading statements that you can make in connection with these. And one of the things that I've really been looking at a lot lately, over the past couple of years, I've really got into these DeFi protocols. And when I try to understand them, the disclosures, I'm not going to ascribe any intent here in any particular case, but their description of the economics of these protocols is so bad, probably because they're written by computer nerds, but they're definitely misdescribing the economics and the functions of how the protocols work in a practical sense. And I think that is going to be used against a lot of different protocols over the next year that people have lost money in.
So, under 10b-5 of the federal securities laws, there is a private right of action 2 years from the date of sale or from the discovery of the fraud that allows an individual investor to bring a claim against direct people in direct sellers, but it also allows for potentially promoters as well. Now, there's kind of a gray area in the promoter stance. Promoter would be like somebody that isn't necessarily a part of the entity, but somebody that the entity is paying to sell. And the SEC has come down against promoters often, but they're doing that under the aider and abettor section of 10b-5. The problem that private individuals have in bringing the private right of action against promoters is that under Motorola v. Scientific Atlanta, the Supreme Court said that 10b-5 does not give a private right of action to individuals against aiders and abettors. Whether a promoter is an aider and abettor or a direct seller, I think still has some room there. So this becomes a strategic avenue for, a class action lawyer like Bill or David or plaintiff's attorneys to look at and how far they want to push the people that are selling to try to recover those assets. So the strategies that are coming along are pretty interesting.
And this was explained in this framework for investment contracts by the SEC, right? Yeah,
that was in July of 2017.
Yeah,
right. So one of the things that's interesting, if you go and I want to save this for Celsius. I was about to jump into Celsius, and I'll hold off. There's just so much.
Yeah,
meat
let me
there.
expand a little bit about what you were saying there too. So if you look at what kind of remedies you can get if you go within the 1 year, somebody does a token sale or a token offering, you can go back and you can say, I want my contributed ETH back. I want it rescission. That's what Jason was talking about. You can say, you know what, I bought it in the ICO. The token took a huge dump and I sold it at an 80% loss. I want that delta between my investment and my sale price. And you can do that directly from what we would call the issuer, or wherever the tokens came from, or the people who are related to where the tokens came from. In the fraud context, okay, you can recover if someone engages in a false or misleading statement in connection with a purchase or sale of securities, or a deceptive or manipulative device. So it doesn't have to be against the offers and the sellers of the security. And a lot of this comes up in the context of, like, let's say market manipulation, right? So let's say I'm just out there operating in a pool and, or operating on a crypto exchange, and I am doing wash trading. Or let's say I'm a DeFi protocol that is a security and I'm making open market operations to try to stabilize and peg that. That's actually illegal under Section 9 of the Exchange Act.
Yeah, it's market manipulation of an underlying investment contract, right?
That's right. So
yeah, I mean, we saw a lot of claims that the SEC brought during the subprime meltdown and threats of those. Part of the reason Bear Stearns melted down was that they were threatened by the vulture fund guy Paulson, that if Bear Stearns tried to rehabilitate these mortgages that Paulson had taken these dark side swap contracts on, that Paulson was going to sue them for market manipulation, which that threat meant that Bear Stearns was going to fail. And the reason we had the subprime meltdown, because he had identified that the subprime mortgage contracts were securities, and any attempt to modify those contracts would be manipulation. And that held water.
Exactly. So, yeah. So think about how this, the litigation that we had in the space, at least that I've been involved in and tracking, is this a security? Is that a security? And I've looked at all of the cases because I have to monitor these over the years in the class actions I'm involved with. Pretty much the answer is yes. In lots of different permutations, people come back and try to say, well, this feature or that feature makes it different. And courts are generally saying, nah, they're securities. So we're not going to have all this litigation over whether something is a security or not. What we're going to have is sort of this assumption that they are, and then all the breadth of remedies that are available under the Exchange Act. And there's a lot of just hanky-panky, that's probably a bad word for this, but there's a lot of just shady conduct that's going on here. And people assume that there's no regulatory environment that applies. And I can tell you, I can see the pipeline. I know what's going to be coming in the next 6 months, and it's going to be a lot of 10B cases.
So what I want to add on that is that the regulatory environment, both at state and federal level, the presumption right from jump is that any cryptocurrency, any token, any crypto plan is a de facto security before they look at the individual implementation of those tokens within any type of internal application. And even though the SEC and the Supreme Court has said that every case is different and every transaction needs to be looked at individually, the regulators, especially the SEC, are coming right out of the door saying, no matter what the token is used for, or no matter what this program is used for, we're going to call it a security. And then they're going to leave it to you, defendant, to try to prove what percentage or what amounts of those things were not securities. At which point SEC v. Lieu comes in, and how much should be attributed to actual legitimate activity versus not legitimate activity, and then it just gets very convoluted. So while your DeFi program may have at its core some level of investment contract, there are circumstances within a lot of these products where their internal token is not being used for any type of investment purpose, but instead is an accounting tool or a date timestamp tool or something along those lines, to where there are arguments to where there are portions that may not be a security. Either way, you're in for a fight to have to prove that.
Well, the rubber really meets the road when people lose money, right? So, you know, and I think that that's where we're going to creatively get the attorneys describing these things in the securities fraud context. And I think you're also going to get sympathetic courts. So some of the things, for example, that I've noticed and I've been looking at, I'm not going to mention any particular projects because we've got some in the skunk works right now. But for example, I mentioned when I go to a protocol and I see that the economics of the protocol are very difficult to understand. And I'm a finance guy. I have a deep breadth and understanding of capital markets and the structure of capital markets. And when I read it and I say, what the fuck is this? Like, I have to read it 20 times. It's not in plain English. I think that could be false and misleading statements that address the purchase and sale of securities. You've also got a lot of situations where various protocols have interventions by the founding team. You know, you'll have a situation where, you know, the way these projects are often structured, you get there's attorneys who think that they're smarter than the SEC and plaintiffs' lawyers, and that you can structure a token event so that you have a protocol that's not really connected with anything, and it's got a foundation behind it that's endowed with hundreds of millions or billions of dollars in ETH or Bitcoin. And then these foundations or the people that run the foundations are intervening in these protocols when market events happen. We've seen that past several months. So I think there's
the most famous of all those foundations interfering was the Ethereum fork, right after the original DAO hack. So you know how that wasn't deemed back then. Just going back to Tone and I's original conversation about how Ethereum was sufficiently centralized to where it should have been treated as an investment contract. When the foundation can come in, make recommendations, and cause the immutable Ethereum network to somehow become mutable, how does that not satisfy those things to move forward? So the concept and construct of these DeFi products that come up with these convoluted attempts to try to bypass securities laws by calling it a reward or calling it, and we'll talk about that with Celsius in a minute. And I see one of the viewers is wanting us to talk about Celsius.
Yeah, we got two other topics. We got two other topics
on the map.
As well, so.
Yeah. So
Can you guys hear me?
Yes. So
okay,
what I was going to roll into and suggest, Bill, if you're ready to do this as well, is in these DeFi projects where certain groups are relying on a DAO in their procedures to try to avoid securities laws. And I know we had it, or we were going to try to talk about DAOs and de facto partnerships today. And I wanted to pass that on to you, Tone, to see if we wanted to move on.
Yeah, let's try to move on. We have two more topics before we get to Celsius. They are both directly related to the story. So from all kinds of angles. First of all, at this point, I believe I am smarter than any lawyer at the SEC based on what I'm reading as their, attempt to go after Ripple. Okay, so like Jesus Christ. So anyway, so that's one story we're going to talk about is the SEC's incompetence in bringing a case against Ripple, which is an obvious, well, even 90% of people in crypto know what bullshit this is. And the SEC can't seem to do anything about it. And the other one that we're going to talk right after Ripple, because this is more of a securities case, is the situation of the DAO, where it's very possible that each member of the DAO is now liable for anything dumb done by any other member of a DAO. And this goes into something Bill said earlier, where there are claims of something crazy. So here are some claims where the people in the DAO said, oh, don't worry, this protocol can't be hacked. And then suddenly money disappears, right? And if one member of a DAO says it, it might be another one. And David Silver has joined us as well. He's on the security side as well. we're gonna move on from the Solana. Let's go on to the Ripple case. I'm gonna let David do a quick intro, and then I don't know whoever is most familiar with what's going on. But basically, in the Ripple case, Ripple is wants to have on record the internal discussions by the SEC that allowed Mr. Hinman creating a dumb-ass statement, if I do say so myself, that Ethereum was sufficiently decentralized. Now, he did say this is his opinion, but for some reason, this has been taken as law by the SEC that Ethereum is sufficiently decentralized and is not a security. And Ripple wants to know how he came to that conclusion, and the SEC is being very secretive on providing that information, and I don't blame them because that was clearly inaccurate, to say the least. So here we are. Ripple is doing incredibly well in this case, also because not enough holders have lost money in Ripple. There is this giant letter written, and all these links are in the video description, guys, that Ripple is not a security, it's not a violation of anything, and Ripple token is the greatest thing in the world of finance. So the Ripple army is still defending Ripple, and the SEC is basically being hung out to dry here. So David just walked away, so we'll get his intro after that. Who wants to go first on this one? Jason, have you been keeping up with this mess?
Yeah, so
and we'll get to the DAO part.
One of the things about the Ripple case is that we've been following it for a while, and David and I have had different predictions and panels that we've done about whether Ripple was going to be successful or not. And I'd held and still believe that Ripple is most likely going to be successful at the district court level, but ultimately will lose on appeal. Just to remind everyone, Ripple's argument is that it's kind of the dog bite statute, which is, it's not my dog. Even if it was my dog, it didn't bite you. And even if it is my dog and it did bite you, it's never bit anyone before. So they're taking kind of the kitchen sink approach of saying, we're not a security, but even if we are a security, you've let us go on doing this stuff for so long that you have effectively waived because you didn't give us fair notice that you were going to enforce this. And so you're stopped from enforcing your securities laws against us now. And so where originally I thought that that argument of fair notice was going to fail because there was absolutely enough, there were enough cases, there was enough law, there was enough enforcement that existed in the United States since 2014 with the Shavers case to explain why these things were bad. The SEC has fallen down so many times in trying to present its case on why fair notice shouldn't apply, that I think they're in danger of seriously losing. And if they do, that's just going to be a floodgate for any of the enforcement actions that any state brings, the SEC brings. There's going to be a real hard time for the regulators to try to stop a lot of these illegitimate or shady types of events from moving forward.
Yeah, if the SEC loses this, that's like such motivation for Tom Vays to launch his own scam coin. You have no idea.
Yeah, me too.
Oh, let me introduce myself and tell everyone why Jason is wrong. Don't get excited. We're in the first inning.
David, just so we're clear, I think you and I both agree that eventually they're going to lose at least at the appellate level, but I think they're going to lose at the district court level. That was my prediction.
Hold on, I've been on hold for 20 minutes, so they just answered. So give me 1 minute and I'll be back.
David's finally able to get back to that automobile warranty program that he's been trying to get for so long.
I've been on hold for them for months now. I think I think
just so you guys know, I'm going to step away for a second to refresh my cup of coffee. But Bill, go ahead.
I think
go ahead,
that
Bill.
the only loss. I think the only loss here is the SEC's public credibility in this. I think that they're definitely going to win.
Right? Like that. That's a big loss. I mean,
yeah.
SEC's public image that they're an enforcer. It's kind of like the U.S. military, but let me not get political, right? Like that image of the is. Anyway, let me stop there. But you guys get the point.
David.
Oh, am I allowed to jump back in? I want to cut off Bill.
Our warranty
but
call?
He's frozen on my
go ahead.
screen with his mouth open.
So, yeah, Bill, your internet connection is a little spotty.
Well, he's in the middle of nowhere now. Look at the fancy Bill's gotten over the years. All of a sudden, he's out of his little office. He's like got this gorgeous background. Crypto's been good to Bill.
All right, Bill, you want to say a few more words, or should we let
that's
David
it. I think that it's very clear that this was an unregistered securities offering, and these see, it looks like Ripple's winning, but what this is just discovery fights over whether Ripple gets a chance to look at these internal SEC documents. And the way judges tend to go is, if I'm going to hang you, I'm going to give you all of the opportunity to defend yourself first. And even if I don't think that it has anything to do with anything, if you think that it's important to defend yourself from the long arm of the SEC, then but at the end of the day, it doesn't matter what they were saying inside the SEC. The law is the law.
So
am I breaking up still?
He broke up a little bit there, but I'll help Bill.
Yeah, well, we got the point. We got that point. That's actually a really good point, Bill. All right, David, introduce yourself and then give us your views on Ripple versus SEC.
David Silver Miller, 2014 to 2018. Every crypto lawsuit had my name on it. I'm no longer famous. I'm no longer young, and I'm no longer good looking, but I am rich now. So my wife loves me even more. So
still waiting on those Cryptsy coins, though, right?
It's still, but there's some good news coming in Cryptsy soon. People are going to be shocked, but we found another batch of money that's coming in. People in Cryptsy are going to get paid once again.
So so is David. So for those that don't know, there is a big chunk of Bitcoin out of Cryptsy that are still sitting on the blockchain and have not moved. And legally,
no, they all moved. Tone, you haven't heard the news.
No, I have not.
2 months ago, all 11,000 Bitcoin moved.
Oh, those are your Bitcoin. You have
those are my Bitcoin. All 11,000 moved, and we have locked up a lot of them. There's some good news coming out in Cryptsy soon.
Man,
I can't say much more than that, but
look at you, Papa Silver over here.
No wonder he's smiling. Look at him.
Exactly. There's some. I've waited years. I can't tell you the exact day. It was like 2-3 months ago. All of a sudden, after not moving for like 8 years, all 11,000 Bitcoin moved. So it is. We are excited about that. It does bode well. Man, we'll do a separate show on that when I can talk publicly about it.
This bear market has really like the things are coming out now. Holy shit.
Oh, wait, hold on. My caller's back. See, every time you talk to me, my call starts again. Give me
desperate. All right, we got a Della to introduce the show. Desperate times are calling for desperate measures. Man, wherever Big Vern is hiding out, this bear market has forced him to move that 11,000 Bitcoin after 8 years. That's incredible. Dells, introduce yourself. How are you? Where are you? You're on mute. So you may want to fix that little problem and give us an intro.
There we go. Yes. Hi, everybody. I'm Dells, aka Bitcoin Khaleesi. I've been in the space for a long time, 12 years at this point. I know Tone for a long time, right, Tone?
Yeah.
Yeah. And I'm a little looped up from being from the dentist at this point because I broke my front teeth last night. Don't ask.
No.
Don't ask, but you should see the other guy.
Oh.
But you know, I only have about 2 minutes because I'm about to leave and travel. What I really wanted to say at this point was that I think the SEC v. Ripple case is so super important because it really does kind of put them in check at this point. And
SEC, not Ripple.
no, it puts the SEC in check, and this is
Right,
good
that's
for
what I
the
mean. SEC in check, yeah.
Yeah, and listen, I'm not a Ripple fan. Do I have some Ripple? Probably. It doesn't matter. But do I think it's a total shitcoin? Yes, I do. But at this point, I really think it does kind of put them on task because, you know, we have this sort of like culture of regulation by enforcement, and I think that really needs to stop. We really need to give a chance to the innovators to do what they need to do and at least get some notice that they're doing something wrong. And that did not happen with Ripple. Ripple was, you know, doing what they do for like 8 years before this action came. And so what does that mean? What does that mean for the industry? What does that mean for someone who's trying to do something cool and innovative? And I'm not saying that they are, but I think it really does kind of put them in check, because at the last hearing, one of the things that happened was that Ripple asserted that they had a special sort of immunity because they're an administrative agency and they can't give insight into their processes as to, you know, why they came up with the decision that Ethereum was not a security. I mean, like, let's think about that. Like, why do you need to have more secrecy than everybody else?
Yeah.
I mean, it's a good question, and the judge was not having it. She said no. Like, you need to turn over the communications, you know, your deliberative process to why you came up with your coming out with saying that Ethereum was not a security. Like, we need to understand this. So
yeah, no, I would love to read those transcripts as well. It would be super interesting. All right,
well, I think the reason that matters is that when it comes to Ripple's fair notice defense, when the SEC is saying, no, you should have known that we were going to enforce against you, Ripple effectively is saying, how the hell are we supposed to read your mind if you're not going to be transparent with how you're going to enforce things? That's the argument. I'm not saying that I agree with it or that I don't agree with it, but that's the argument that then says that all of those internal communications based on the when Howie met Gary Plastic speech and Hinman's analysis that Ethereum was not a security, that somehow that was not an official statement of the SEC when obviously it was, on how they were going to enforce things. If the Hinman speech was supposed to be noticed to people on how things were going to move forward, then if they've treated Ethereum a certain way, they need to know why that was treated that way and what deliberations took place, because there wasn't really, I mean, other than the Hinman 13 points of how they're going to view things, not one of them being dispositive, what the internal analysis was is relevant. And so I think the judge rightly decided that the internal machinations and thought processes of the SEC needed to come out and be exposed in order to shed light on how it was enforcing against Ripple versus why it's not enforcing against.
And David left again. I was just about to cut you off, Jason, and go to David. Well,
it was fine. I was just wrapping up. Anyway. But David's still trying to get his car warranty sorted out. So.
All right. Okay, there he is. David, now you're muted. He's back on the call. All right.
So it's actually funny because so then the SEC said, well, if we put light on the deliberative process, that it could be harmful to the market. And so this raises a lot of questions, because a few companies have gone public and, you know, put light on the fact that they have been exchanging Ripple or using Ripple. So what does that mean? Like, you didn't say anything to these companies who were going public when they filed. Guys, sorry, I'm a little loopy from my dentist appointment, but you know, you didn't give us any note. You didn't give them any notice when they were going public, when they were, exchanging Ripple. So I mean, what does that mean? Are the rules for like one set of people, not for another set of people? Like what does that mean?
Well, hopefully we will find out. All right, you know what? Simon Dixon will be joining us in about 10-15 minutes, and then we're gonna start the Celsius talk. We will get back to get David's views on Ripple versus SEC, but we do have one more story to cover before we get to Celsius, and that is this class action lawsuit against some token company, whatever the hell it is. I've never heard of it until today. BZX protocol, which is a traditional DAO, whatever a traditional DAO means. And Jason Seibert and I had this discussion months and months ago.
Maybe even over a year ago, Tone.
Yeah,
I think
it's been a while, and I wish we would just did a spaces over our phone call where basically, and this is exactly what Jason said about a year ago, that when you form a DAO and you think you're forming a DAO to absorb yourself and remove yourself from liability of the people in the DAO, when in reality, it could become a situation like this lawsuit claims, where a single DAO member's claim is now like a legal liability for every member inside that DAO, which is insane. It's kind of like a general partnership. If you and your partner have a business and your partner does something stupid, suddenly you are liable for your partner's misdeeds. And this is super interesting because it kind of puts a big kibosh on, oh, it's a DAO, so it's not my fault. Jason, why don't you give us a little bit of a background on this? Maybe not this specific case, but this specific concept. But there are links to this specific case, and it is actually super interesting on some of the claims that were stated by the DAO members, where they say, ever worry about it, getting hacked or stealing funds? Like, don't worry about that, and then it happens. So it's very interesting. Jason, floor is yours.
Sure. So when you talk about business organizations, I'm going to go back a little bit to kind of first year law school of how businesses set up, how they organize, and how the law treats these constructs and liability in these constructs when analyzing who should be liable for contract performance, for debts, for what have you. So when one person starts a business, we'll just say a lemonade stand, and they don't form any kind of an entity, they're just doing it by themselves, that's called a sole proprietor. All right. Now, if that sole proprietor says, I'm going to have this lemonade stand and my neighbor has really good lemons, we're going to run this lemonade stand together, and we're going to share in the expenses and we're going to share in the profits. The two neighbors running the lemonade stand now, whether they know it or not, have formed what's called a de facto partnership. They are operating with the interests of running a successful lemonade stand. They're sharing the expenses, they're sharing the profits, and they're moving forward in that concern. So you get somebody, again, down the street says, hey, this is fantastic, I want to be a part of this. Now you have a third person. And so now three people are sharing expenses and they're sharing profits, and they haven't formed any formal organization or entity. Now you have three people in a de facto partnership running that lemonade stand, and all three are liable for the acts of the three others. So if the neighbor down the street, that's de facto partner 3, goes to the store and opens up a tab and buys $1,000 worth of lemons without any of the other partners knowing about it, and then leaves town, the two partners are liable to pay that $1,000 bill because the de facto partner was acting in the interest of the partnership. So it gets kind of messy. That's why lawyers prefer, when people are going to go into business, that they form some form of legal entity where the entity itself is responsible and not the individuals. It's just cleaner that way. So one of the things within cryptocurrency that this is all the way back when we talk about the original Steve Toole Slock.it DAO that created the Ethereum fork, was that people were convinced that the DAO structure at that point in time, which was an investment vehicle, had somehow solved Howey, because there was allegedly no centralized management and control. This was false. In fact, the SEC's DAO report that they did after that said that there was centralized control, and they pointed at Slock.it and Steve Toole and the people that had formed it for that. What they didn't do is analyze the liability of the individual DAO members that had put money into it. Anybody that puts money into a going concern where they expect to share the expenses and profits out of it without forming any type of legalized entity. And we've seen this, and Bill and I were talking about this earlier. Over the last year, we've seen courts and plaintiffs' lawyers start to approach, like this BZX case has done, start to approach that DAO as that de facto partnership. And I was trying to remember earlier today, but there was a very relevant case that involved Dole Pineapple out of Florida, where they were storing pineapple from somebody else in their freezer, and nobody thought that that would ever become a de facto partnership, but it did. And I'll try to find that case later and give you that link, Tone, so that the other lawyers that are watching this, or people that are curious about de facto partnerships and how to organize DAOs.
Hi, SCC. We know you're watching.
Yeah. Right. So anyway, that's my background on DAOs and de facto partnerships. Bill, did I miss anything there?
Muted, Bill.
I want to hear what Papa Silver has to say. And I will admit, you are so much better looking now that you're rich, that you're really rich. It's just like, it's a glow. It's just glow. Those Cripsy Bitcoin are just glowing.
Oh my God. Jason had a crash on my couch the other night. We had to drink wine out of a box. We could barely feed my dog.
Yeah. All right. David, get back into this conversation. You already gave your intro. We've kind of moved on from the Ripple SEC case a little bit because Simon Dixon is going to join us, and all of next hour is going to be Celsius. So we have two stories. We have the Ripple versus SEC, and this whole concept of a DAO being a de facto partnership, because in order for them to get around regulation, they decided not to file as a legal entity. But now that means every member of the DAO is liable for anything done by any other member of the DAO. So you can comment on both of these in any order you like. We would love to hear from you.
Okay. So naturally, my phone just picked up and they're back on talking to me. Hold on a second. It's like seriously, it's ridiculous.
Okay, so I'll jump in with that a little bit. I don't think that this idea that everybody is liable for everybody is really something people have to be concerned about. But if you're a bad actor and you cause others losses, then yes, then you should be concerned about it. And I think that there's a ton of lawyers in this space smarter than me who've been talking about this issue of general partnership liability for years. Jason's one. I know Drew Hinkes is another.
Yeah, Drew and I and you, I think we've all had this discussion over the last year in some form or another about how to advise people or how to approach the DAO scenario. And it's been very interesting that it's taken until BZX for somebody to actually jump onto that.
Well, I think the theory applies for DAOs. I think it also applies for DEXs, okay? And I'm looking at this in the context of something that's through the pipeline. It's a little bit more difficult if you try to bring a class action against this. And this is using this theory. Now, it's one thing to say, I'm one member of the DAO, and I'm going to point my finger at, let's say a foundation or the people that launched it or an entity that launched it. It's very different to say, I'm going to have a class of people bring a claim against those. And the reason why is, well, where is the partnership and what law are you going to use to define the partnership? Let's say I'm in California. Are we going to use California's state law and you're in the Seychelles? Are we going to use the Seychelles? Right. So when you can't really shave off those, what they're called choice of law issues in a class action very easily. And I think it's going to be hard to certify this type of a claim. I mean, I'm trying to think of ways around it because I think it's kind of clever. And in the context of And in the context of these fraud cases that I think we're going to be seeing coming through the pipeline under the securities laws, one of the interesting things is in a normal securities fraud case, you can't bring state law claims related to it because of this statute called the SLUSA. However, the SLUSA only applies to a covered security, right? A covered security is a security traded on an exchange, right? A registered security traded on an exchange. So I think what we're going to see is we're going to see these fraud actions and these partnership actions brought together, and we're going to let the courts kind of sort it out and see what the best way to make liability stick to various parties. Are you back yet, Silver?
They just hung up on me and told me they have to send me an email. And for those people who are thinking that this is not crypto related, this is an exchange who I am suing right now, who literally put me on hold for 45 minutes because they owe me money. And I was like, anyone else? I was like, I want my crypto. So I know the next exchange to go down.
All right, Dels, you have I know you have to run. I don't know if you want to say anything else real quick, and then we're finally going to give Silver the floor. Nope, you muted. Oh, yes, not. You muted. Dels, you muted.
Yeah, I'm just gonna say hi and bye and listen in as I travel, but
All right,
I can
perfect.
bounce.
All right,
Hi and
stick
bye, guys.
around.
Nice to see you. Lovely. Your teeth look great, whatever they did to them.
Yeah.
I'm loopy.
Yeah.
I'm loopy, but it's all good. I'll see you guys.
Later, Dels. All right, Silver, you got 5 minutes, and then Simon Dixon is going to join us, and we're going to talk Celsius. So go. You got two stories. You got the DAO situation, and you got the Ripple case.
So let's go back first to Ripple, because I did start this by saying Jason was wrong. As usual, Jason is wrong. And I think Bill actually nailed why Jason's wrong. People are confusing early discovery battles with who's going to win and lose this case. The Hinman actually, speech that the SEC tried to protect. It was interesting. They said it was going to be his personal opinion, but then they tried attaching attorney-client privilege / work product to what actually happened to withhold the rest of the information. So I still say Ripple is going to eventually lose. They're going to eventually settle. There's too much money. The DAO, since Simon joined us and he's the man of the hour, I'm going to say about the DAO. DAO is yet another
David, it doesn't matter because they've already won in a court of public opinion.
Yeah, I don't believe that.
Are you kidding?
Della, you were leaving. You were leaving. Don't come back in and say. Don't come back in and say silly things.
Back, bro.
Hold on, just so we all remember, Adela prefaced her appearance here by saying that she's on serious painkillers from going to the dentist. So anything she says or doesn't say, we'll just attribute to the medicine.
Adela, tricks are for kids. Come on, don't forget that.
Sidebar for that, okay? Sidebar.
We'll sidebar that one. So ultimately, they're going to pay a fine. It's going to be a large fine. We'll all be good. The DAO. I am a securities lawyer. Bill Restis was talking all these fancy acronyms. Even I can't follow the SLUSA, the PLSRA. What does this? What does that? At the end of the day, the DAO is a made-up term. There is no legal precedence for what a DAO is, what an ICO is. And we'll get into Celsius in a second. We'll talk about more made-up terms. But at the end of the day, the DAO is a made-up term. Partnership law has been around for 100 years. You are partners with the people you do business with. The government does not care that you call yourselves a DAO. They don't believe in decentralization. I don't believe in decentralization. Decentralization is a myth. It's been a myth since day one. Someone always gets rich and someone always loses their money. That's the only way the world has worked since the days of people selling wampum back, when we came in and bought bridges from Indians. Like, come on. Like, if it's, I want to make fun of Celsius just yet, because I'm gonna let Simon get into that. But ultimately, this is really, really simple. If you are partners with other people and they do something wrong to you, you have a cause of action. If you're a shareholder in a company and the majority does something wrong, you have what's called minority shareholder rights. There are always going to be rights for people who get screwed to simply say, well, this is crypto and it's decentralized. That doesn't work. I'd be living in a 1-bedroom apartment, and my wife would leave me because I couldn't even afford the box of wine I gave Jason when he visited. At the
And
end of the day,
that was a good box of wine, by the way, and we enjoyed that out, in the back. So in case people don't know, David's deck is right on a piece of water that's infested with hallucinogenic frogs and alligators. And David has lost so much money in crypto that his deck is comprised of pallets from the warehouse down the street. So we had a spool that we picked up from the side of the road that we put the box of wine on, and we were watching his dog lick the hallucinogenic toads and drinking wine. It was a fantastic experience, David. It was a
Why are
life-changing
people
experience.
drinking box wine? What is going on? I think are things back so bad in the States that people are drinking box wine? What's going on?
Box wine is super underrated, by the way.
Okay.
when Bitcoin's over 40,000, Tone and I live different lifestyles. Under 40,000, we gotta find good boxed wine. It just is what it is. It's where the market is. Okay,
Yeah,
so I think I hit the DAO. I think we can go, Tone. Simon's here. Let him give
Right,
his.
Simon's
Let him do
here.
what he wants.
Simon, do a quick intro on yourself. You are, along with myself, not really lawyers, but have a lot of experience in this stuff by now and a huge historical financial background. And I will pull up your Twitter handle as you give your quick background.
Okay, cool. Is my mic working? Can you hear me?
Yes.
Okay, awesome. Yeah, I've been on Tone's show. We only tend to go during dramatic times, like when Bitcoin's hard forking or Bitcoin pizza days and all sorts of stuff. And now it's the Celsius one. So Celsius has kind of taken over my life over the last couple of weeks. I was unfortunate enough to invest in the company and host a funding round on banktothefuture.com. By way of background, I wrote the first published book in the world to include Bitcoin. I co-founded banktothefuture.com, which is a shareholder and responsible for funding in over 100 companies in the industry, many of which David Silver was always involved in a case with. So it's always interesting, but it's good fun. Yeah, so just an investor in the industry. First bought Bitcoin at $3 and just been investing since. So that's me. One of the companies I invested in is a shareholder in Celsius. We invested in their Series A funding round. We pulled together 10 million on Bank to the Future, and Tether invested 10 million as well. I also bought into the concept of a peer-to-peer Bitcoin lending platform. I wanted to not sell some Bitcoin and pull out some money. So I started to go and see the different companies that were making that possible. One of them was BlockFi, another was Celsius, and there were some other companies that I'd invested in prior to that as well as the industry grew. And then I also put some more there because I wanted the yield that I received on that Bitcoin to pay for the interest that I was going to be paying to pull out some money. So through this mechanism, I ended up with tens of millions of dollars on Celsius. And just for transparency, mentally, I'm okay losing that money. That's where I'm at the moment.
Was that your personal? Just a question. Was that your personal investment, or was that through Bank to the Future on behalf of other users?
No, that's my personal.
Okay.
Yeah, that's my. I take a more speculative approach with a percentage of my own money as opposed to so that's my personal account, and I do have other accounts as well. So. That's the disclosure. I don't own any Cell token. I did find some Cell token in my account, which is minuscule, a tiny amount. I must have pressed the wrong button when I first was playing around. So that's a full disclosure. But, it wasn't a deliberate, I've never bought any Cell tokens or anything like that. So when they suspended withdrawals, I was in the midst of a timeout in my career. My father sadly passed and I was taking some time out. I had to come out of that because I was just getting message after message from people on the verge of suicide because they put their entire life savings. And it started to ring true. I'm sure you've all been involved in some of the major, more deliberate scams where they weren't actually doing anything, as opposed to, sometimes someone starts out with good intent and then get in over their head, and then it becomes a bigger mess, and then they try to cover that mess, and you end up with a bigger hole, versus something like, OneCoin or something like that. But I remember hearing from many victims of OneCoin, and they got their whole family in, they got their, and literally their entire future was vested in that project. And I started to see more and more messages like that. So I had to dig a bit deeper. I immediately realized that as more and more people sent me videos of Alex Mazinski talking and how he represented this product, it started to really give me some deep concerns. That video really sums it all up.
Let me play one of these videos real quick. It's super short. I hope the audio comes through.
We're working in conjunction with them. We provide the liquidity. Actually, Compound and Avid pays a huge portion of your yield, right? Because they pay us fees. Right? When we provide liquidity for Avid, they pay us fees. The other user on Avid pay us fees for your liquidity, and you get to keep most of it. Right? That is the beauty of it. Now, you don't have to worry about it. You don't have to know all the security stuff, right? And Celsius takes full responsibility. If anything goes bad, we take full responsibility. That's part of why we raised at 750 million. And now we have over $2 billion on our balance sheet. Again, more than anybody else. Ask Nexo how much they have on their balance sheet, right? Ask BlockFi how much they have on their balance sheet, right? Ask all these people, right? So what's important for you is you need to know, okay, if something goes wrong, that these people are going to stand behind, or they're going to say, sorry, I don't cover it. It's your loss. Sorry, goodbye, take it or leave it, and so on. Why? Because they're cash, right? And they don't try to build a long-term business, right? They just try to grab fees from it. So all these things matter. And Celsius was tested every year. We were tested several times. Sometimes the market drops 50%. Is Celsius doing good? Yep, Celsius doing good. Something bad happens with the Celsius deployment. The Celsius.
Yeah, so just a few of those. I'll jump in and comment on. Yeah, I'll comment on a few of those. So the $2 billion balance sheet, as we started to look deeper and deeper. So firstly, how did I get to this?
Celsius, it was in the Celsius token, my guess. And when that Celsius token goes to zero, there goes their money.
Yeah, so these representations are on a highly illiquid token that was filed a Form D. So therefore, Alex represented to the SEC that this is a security, that he then used that in order to tell the world that this is regulated and signed off by the SEC, rather than saying that's just a disclosure for us raising finance. That was then used in order to those tests of the market. The FT covered that during those tests, Alex was on AMAs telling everyone to buy tokens while he was selling his tokens, and pulling out millions from these tokens at the same time. This is what he's calling the collateral. So then people were buying these sell tokens, depositing them in Celsius, borrowing dollars against the sell, and then using it to buy the sell that was then being sold in this vicious cycle, in this vicious loop. Now, the reason that this started to become an issue is because we'd invested in the Series A, and suddenly there was this announcement that 400 million had been raised, and then that suddenly turned into 750 million has been raised, and we have, we're meant to get preemption rights on that, and so we contacted Alex and asked about the preemption rights, and then he said, we were then put together with the team, and then the team said, okay, mistake, let's figure out how we get you in that round. And in that round, it took us about 8 months of due diligence, and we still didn't get the financial documents and the regulatory documents that we were requesting in order to do a full disclosure to those that were already in the round, because there was SEC action, there was state action, There was a removal of the UK company from the FCA. And then when you started to hear videos, like this, I didn't see this in retrospect. I wasn't following along. Apparently, these videos were happening every week. This peer-to-peer Bitcoin market that I thought we had originally invested in suddenly turned into a DeFi hedge fund, and it was still continuing to be represented as a low-risk savings account to people that were essentially I'm not even talking about crypto degens. I'm talking about, people that were saying, all right, I'll take my retirement funds and I can get a safer than a bank returns based upon the promise of how this is represented. And I'm going to take everything and get the returns that were generated on a promise of higher returns, lower risk, no fees, not a security, no, you should be taking a percentage of this, no suitability testing. And essentially it was stable coins, and it became this unlicensed securities business from my perspective. And then as things started to go missing, when there's holes and there's hacks and there's all sorts of things, rather than fessing up and saying, right, it turns out you can't have instant withdrawals at the same time as putting all of this and leveraging this all up and levering it all up into all sorts of different types of projects. Instead of doing that, he went around all these different YouTube channels and told everyone that everything's safe, everything's good, put more money in, contacted our business development team and saying, can you get more? We were building a security law compliant version. Can you get more retirement funds in here? Can you get more banks?
Hey,
Sorry.
Simon, sorry. So it's at this point, it's grossly obvious there was all kinds of I want to use the right word here, all kinds of shenanigans. I don't want to use the word fraud, but it probably was, but that's a legal term. So there was all kinds of horribleness going on. I really want to play this really short clip. I think I was the first person to call this out publicly. I don't know if you saw that little video, but this discussion for the next 40 minutes is going to be what happens now. What happens to the people that had loans? What happens to what goes forward? It's obvious that all kinds of bad stuff went on, and I'm sure there's many podcasts that explain all the bad stuff that had happened. I found this video, guys. All these links are in the video description. This is the full video. I'm gonna save you the time. I'm just gonna play this little short clip, and then from there we're gonna talk about what happens now, because it should have been obvious that he was gonna end up running a Ponzi scheme eventually.
In more than one use case, but I'll give you an example. Celsius Network pays interest once a week. We can put 1 billion people on the Ethereum platform using Celsius. We are an ERC20 token, and we can support that application tomorrow. There's no problem with scale.
So why are you using it?
We are using it exactly because of that. We're using it because the only way today for everybody on the planet to earn 7% interest, 7 times more than the bank, is using the blockchain, using Bitcoin, using stable coins.
You realize you just said something that's impossible, right? Everyone on the planet to earn 7% interest, right? You realize you just said that, right?
Impossible.
It is impossible. The money doesn't grow on trees. You can't give everyone 7% a year.
Earns 24% on your money.
So let's make sure we can all be heard.
The point is, their business, the business model is taking your money and giving it to someone else. Okay? If you're in
The problem with
give
this is
95% of your value.
the problem with this is very typical in this space. People exactly. Let's call bullshit. People identify real problems in the world and then present some sort of nonsensical vision of a beautiful world in which everyone pays 9 and everyone receives 7%, and somehow that's supposed to be a solution. It's not a solution. Yes, banks do take advantage of people. The reasons are institutional and political.
Can they pay 7% today without losing money?
There are a lot of things wrong with banking.
Yes or no? Yes or no?
I'm just here to
Can
point out
bank pay
the ridiculous
7%
notion
today
that you're
without
not going to
losing
offer
money?
7%.
Right, okay.
It's just
No.
another.
Guys,
This is just another blockchain nonsensical use case.
Money. Yes. The answer is yes.
Okay, I
They
think
just don't want to.
I think
All right, there is more of that.
Yeah.
I'm assuming. you guys can-
Let me jump in for a second, because now we're into my. I usually do this, explaining things simply when Jason has to speak, but I'm gonna do a little for Simon right now. Hold on. Basically, there's two really, really important things that Simon said here, and I want to parse them out for how people are going to move forward. The first thing is there are a lot more lawsuits. There's a lot more in the bankruptcy. The reason why Alex Mashinsky did not want to file bankruptcy was because if you lie in bankruptcy, that in and of itself is a crime. And lying in bankruptcy is going to be the reason Alex Mashinsky goes to jail. Like, let's just be clear here. He was forced into it this week because when Vermont published what no one else had published, that Celsius was a Ponzi scheme, he had to file bankruptcy because all of the state regulators were coming, the lawsuits were coming. I personally represent several hundred clients. There are more lawsuits coming from us. But let's be clear, because
David, hold on a second. Procedurally speaking, the reason that the timing of the bankruptcy had to be filed when it was filed is that if a state regulator or the SEC jumped in and did any type of action, they would have sought an immediate court order to freeze every single asset that Celsius had in order to prevent any further loss.
100%.
So in order to prevent a complete and total freeze of everything, I think from a community standpoint for Celsius, it was probably better that Celsius filed for bankruptcy in the alternative of just having everything seized by a government entity. I just
stop using the word community. I hate the word community. There is no community.
That's the worst word in crypto. It's the worst word.
Guys, don't get goddamn triggered. Go fuck off to your safe space for a second. The point that I'm making is the users of the Celsius platform benefited from the bankruptcy instead of the state takeover.
My point is slightly different. Mashinsky desperately made those payouts to grab back the collateral because he wants to remain in control. Alex Mashinsky has 30 days or less left. He's done. Let's just be clear. He's out. The lawsuits, the civil, the criminal, Department of Justice, SEC, IRS investigations, everyone's coming in for Alex Mashinsky. There is no Celsius anymore. What moron would give Celsius money at this point if they did release? First of all, I know people watching this think they're getting 55 cents on the dollar back right now. You are not getting 55 cents on the dollar back. You cannot read bankruptcy filings. You don't understand what has been given value versus what's being given as illiquid market value, what can't be liquefied. The amount that people are going to get back right now, if things move forward in a classic sense, maybe 15 cents on the dollar, maybe if they're lucky, maybe 20, because all this is a rising tide against the price of Bitcoin. But what's going to happen here is, and what the bankruptcy is going to show, is the actual underbelly of what Celsius was doing. And Simon tried hitting on this, but I don't think the users, I'm speaking to hundreds of people a day. What the average user of Celsius doesn't understand is the product they were sold is not the business of Celsius. And the bankruptcy is going to reveal all of that. The affidavit showed Celsius was basically bankrupt since 2021, early to mid 2021. It causes such problems, but Mashinsky had to sign that affidavit because if he signed any other affidavit, he would go to jail. He's got to stand by what he said publicly. So I want to throw out, because Tone keeps saying, what's going to happen moving forward? Here's what's going to happen moving forward. People like Simon are going to hire some of the best law firms in the world to unravel, outside of the bankruptcy, some of the people who received some of the largest payouts in history to collect that money outside of the bankruptcy. Inside the bankruptcy, 3 to 5 years of a restructure / liquidation. The only way a restructure for Celsius would work is if Celsius actually could produce 7% yield. Tone, I love you to death, but Peter Schiff has the same exact video you do, making fun of Mashinsky, saying Bitcoin does not yield anything. Stop telling me that crypto has a yield. Crypto has 0 yield. There is no yield on Bitcoin. Bitcoin itself does not generate a yield. Every time Mashinsky said that, he knew he was lying. People like Tone could appreciate that and said, you're lying. I'm gonna let the other evil person on that stage stay unnamed. But they are 100% right. I rarely agree, but this was so. Anytime someone says they can provide yield year over year in a perfect model. They're lying. No one can do that. So ultimately, there are three things that are going to happen. One, you're going to see a lot more lawsuits outside of the bankruptcy. I anticipate a lot of people are going to actually declare bankruptcy. So that'll be drawn in. Two, in the bankruptcy, you're going to see a creditors committee. I hope someone like Simon would sit on the creditors committee. You'll find a lot of people in crypto aren't going to want to sit on the creditors committee. They're going to hire one of the largest law firms in the world to do the bankruptcy work on behalf of the creditors committee. Minimum 3 to 5 years before there's going to be any money paid out, before anyone knows what's going on. And number three, Simon talks about it, and I can't emphasize this enough. People need to have their come to Jesus moment that their money is gone. I am talking to people suicidal, lost their money, their family's money. People who bought Ethereum. I have a couple of clients bought Ethereum at like $5, said, okay, I want to de-risk my investments, pull it out, put it into Celsius in late 2021, and all of their money is gone. The only way that people right now are going to see a ROI of their money, if Celsius tomorrow liquidates and there was a 50% offer, don't pay your lawyers, grab that, because you're never going to see a better deal than that. And unfortunately, that's just not going to happen.
Well, no, I slightly differ on that, David. So like what we've been working on is a solution that we think is better. We think that there's taking the assets, putting into a new entity, using Chapter 11 in order to try and get the community to vote on a proposal that does better. We've got the securities law licenses. We've applied for investment banking licenses. We've got a model that we think is viable to combine, Bitcoin investment banking. And the only thing that's getting in the way of that right now is Alex Mashinsky trying to protect himself against the interest of those that we think could have a better result.
I don't disagree with anything you just said, but that was the suggestion. I understand why the community would support that for you guys to do. I'll use the community because now you're talking about, first of all, you'd be wiping out.
Wait a minute. You're allowed to use the word community and I'm not?
Well, I'm using community in the sense of all the people who got screwed. I'm defining community as everyone who lost all their money. But ultimately, that's not what the bankruptcy courts does. That will never go through the bankruptcy court. That would be
it's working with Voyager. Voyager does not have a CEO that's trying to block the process of reorgs and plans in order to get back to business by using a new restructure. Voyager's, because it had public company level, finances, governance, disclosures. Yeah, they fucked up. They lent over 50% to one counterparty that blew up. But we're seeing the complete difference. You can see in the Voyager Chapter 11, they're saying, here's the plan, here's how we get out of it. We just got to try and make some value for the equity. And then people are discussing and putting together proposals of how to get out of the equity.
But you're talking a way to still generate the yield. So that's the problem here for people who everyone who calls me up always says the same thing. I invested in the Ponzi scheme. I lost all my money. But David, do you know anywhere I can go where I can still get the 7% yield? And the answer is no, I never know that.
No, I received, it's on Bitcoin. It was, it was between 1% and 3%.
Of course, I don't disagree with that. My point is the difference between Voyager and what you're discussing here. Voyager, the business model. Well, first of all, it hasn't been approved out of the bankruptcy to do what you're discussing. That's people's recommendations and wants and desires.
No, ultimately, Voyager's in Chapter 11, and they're currently
3 weeks.
Real.
Yeah, for like 3 weeks though. Nothing happens in bankruptcy that quickly.
And look at the level of disclosures of their assets as well. They're focused on solutions.
So let me just point out a couple of differences here and kind of set timeline expectations, at least procedurally, because there's, we can talk about speculation of what may or what may not happen. One, the filings just started hitting on Wednesday night and Thursday morning. And so, we haven't even, it wasn't until this morning until we saw the judge even making comment on motions to admit certain lawyers pro hoc vice. So we're so at the beginning process of the Celsius bankruptcy. On top of that, they filed for the bankruptcy to be considered a mega bankruptcy, which means they're going to get extensions of time in order to make certain filings, indexes, claims, what have you, that we're not going to get any type of real picture of the scenario of what's going on with Celsius for at least a month, based on what are, presumed extensions of time in order to get these filings in. So we can sit here and try to make predictions of what's going to happen in 30 days if Mashinsky is still going to be there or not. I don't think that's realistic. I think based on what the proposed bankruptcy attorneys are doing for Celsius right now, so they're going to push this out as far as they can. On the note of Mashinsky's affidavit/declaration that was filed yesterday, one of the things that I thought was interesting in there is that he's effectively kind of whitewashing. Sure, we had some strategic issues that were maybe wrong in the beginning, but we corrected those, and it was Luna's fault that we failed. This type of blaming, anybody that understands what happened within the market, that's 100% wrong. It was all the decisions that were made from the beginning that led them to their vulnerability spot, even though they admitted in that affidavit, Mashinsky admitted that they had made bad decisions that had put them in a vulnerable spot. Not once when they were vulnerable did they ever disclose to its users and its platform that they were vulnerable. On top of that, one thing that I noted, and I don't know if you guys picked up on this or not, but within that within the Mashinsky declaration, it does not disclose at all that Celsius is currently under active cease and desist orders from at least 3 different states to not offer its earn rewards programs.
And I think it's 4 at this point, honestly.
Sure.
It's 5, to be quite frank, because I
Right.
looked at
Jason.
back to
I said at least, that was my modifier, but the point that I was trying to make there is that there should have been a fundamental disclosure to the Celsius platform, to its users, that there is regulatory action that's going on right now, starting back in September 2021, that may have affected or impacted the ability of Celsius to continue on with its business model. And the failure of them to disclose that is a material omission. Now, in October of 2021, there is one video, there was an interview with CNBC that I found, where Mashinsky says, we're not doing anything wrong. We haven't done anything illegal. And these regulators don't know what they're talking about. So if I look into a crystal ball, and if any of that information gets in front of the federal bankruptcy judge that says, is Mashinsky the right person to continue leading Celsius moving forward, when you have somebody that's failed to notify its platform users, somebody who has defied state cease and desist orders, that doesn't recognize when people are doing wrong things and they're violating law. If we're talking about probabilistic avenues of when things are going to happen, or if Mashinsky is going to lead Celsius into the future in a restructuring, I would put that probability at a very low percentage, just based on his manifest disregard for the law and refusal to follow regulatory agencies' orders.
Wait a second. How much Celsius did he sell personally and to people around him, his wife and all that? Then when he said publicly, all founders have not sold any Celsius, and he liquefied Celsius from the company that he sold and used company funds. This man has lots. I have to be very careful. I get sued for defamation all the time. Let me be careful. This man has lots of problems.
Well, one of the things that's also interesting, if you look at the initial bankruptcy filings, they've listed their top 50 creditors in there. And I think the lowest dollar amount creditor is at about, and I might get this wrong, but I think it's about 5.5 million is their lowest amount creditor. And I don't have the exact number in front of me, but of the 50 top creditors that are listed, only 10 of them, approximately 10 of them, have actually been identified. The other 40-ish or so are listed as anonymous. You don't get anonymity in bankruptcy when you're begging the court for forgiveness from debt. You need to disclose who those people are, right? If it's Mashinsky's cousin that has a $20 million claim against it, or an entity that Mashinsky actually owns himself, right? There's so many different conflicts there. Now, what we can predict is in the next couple of weeks, the court will most likely order the disclosure of who those 50 people are in order to be transparent. But right now, when you're talking about the top creditors and they're anonymous, I don't want an anonymous person sitting on the creditors committee that isn't willing to put themselves forward in the bankruptcy filing, that it's now going to, using David's term here, this isn't mine, make representations or do things in the best interest of the creditor community or the unsecured creditor community. I'd rather have those people stand up and identify themselves leading the charge, which means if you're a $20 million unsecured creditor and you expect to be paid back, and you're going to stand there and say, no, I want to be given priority first, but I want to be anonymous, that's not how it works. You know, from an equitable standpoint, you should step forward and have to identify.
Yeah, he's also got a $600 million sell line, a completely, you know,
where did that come from?
Mine. This guy thinks that he's gonna be able to repay this with some Bitcoin mining, get himself out of a hole, whitewash all of the you know, the things that we know are happening, and you know, and become and just long this out for months and months and months, block all recovery plans so that he can just save his ass, and think that he's going to run this company again in the future.
Well,
with
Simon,
no regulations, no licenses.
Correct me if I'm wrong, but the mining operation isn't even running yet, right?
No, mining operation, according to the paperwork in the bankruptcy, is generating 14 Bitcoin a day.
I heard that's all bullshit. Like
I'm sure it is. But again, lying in bankruptcy. Lying in bankruptcy.
No, I'm currently in a hotel to speak to people that know what they're talking about in that mining.
Hi,
and
guys.
I call BS.
Can you hear me?
Yes.
Yeah, Simon, have you
Yeah.
had a conversation with Alex?
Yes, and he invited me on the board to shut me up so that I could sign an NDA and,
obviously
help him fix his bag.
Well, if you're on the board, you're going to have obligations to the company, which will really just kind of shut you up from what you can say.
That's why I declined.
At that point.
Also blows out your equity.
Yeah.
And
then I was put in touch with the investment bank to give them a strategy. That strategy was a perfectly viable strategy that has worked for previous companies with experience to get out of distressed situations. And that was being blocked simply because there is one person that is trying to protect his ass, and that's costing people a lot of money.
Call him out, Simon. I mean, do it.
I've spent the last 2 weeks gradually having my reputation pulled under the, you know, under every piece of scrutiny by people that own sell tokens that are trying to, you know, get more people to buy sell tokens because they believe that there's this grand conspiracy that Max Kaiser, Corey, and FTX are exposing the hero that made them financially free, and he represents freedom of the people, and that we're all the banks and everybody's trying to take Alex down because he's the true hero that's going to be the savior.
So there was hold on. There was a question earlier in the YouTube group that asked whether or not I thought individual lawsuits would bog down any recovery plan from Simon. And I just wanted to address that before it got too lost in the mix. So individual lawsuits that were filed prior to the bankruptcy filing are under an automatic stay from the bankruptcy court so that they are not allowed to proceed unless given permission by the bankruptcy court to have relief from the stay. So the answer to the question, which was, would individual lawsuits that were filed prior to the bankruptcy bog down any plan proposal? The answer to that is no, because everything is put on pause during the bankruptcy. Now, some of the cases may be considered what's called non-core to the bankruptcy issues and allowed to proceed outside of bankruptcy for determination. And if that happens, that still happens on its own. Any result of that still comes back to the bankruptcy court for whatever judgment may happen there for approval or for distribution. So again, even though there may already be existing lawsuits that are filed, full disclosure, I have an arbitration that I filed the other day prior to the bankruptcy filing. That's on hold pending the Chapter 11 and pending permission from the court to move forward. So there wouldn't be a bog down there. Sorry, go ahead.
Real quick.
Yeah.
Go ahead, Simon. I'll let you go, but then I'm gonna be a moderator.
Okay, yeah, sure. So now I'm in the situation where they're trying to, I believe, the new directors, and by the way, lawyers are changed because lawyers wanted Mashinsky to do the right thing, so he fires them, and then another law firm comes along and want him to do the right thing, then he fires them. And then finally, there is now a law firm that is representing that the best interest of the company and Maszynski are probably aligned, but it's certainly not in the interest of creditors, the way that it's being represented at the moment. And yeah, I'm being asked to either join the committee when I've got a recovery plan. I want to put together a plan that I believe can make depositors, if there's obviously risk involved, but I believe there's a viable plan that we can present that will get a much, much better result.
David looks like his head's going to explode.
Real quick, David.
People just don't understand how bankruptcy works. It's just there's no fundamental understanding. Like, we could talk about anything we want, but in the next 30 to 60 days, Maszynski is out. In the next 60 days to call it 4 months, there will be a creditors committee. There will be lawyers who step in to do lots of different things. But there's nothing happening in the near future.
have to pick the right choice, right? I understand you want it to go down litigation. We understand that I want it to go down a recovery plan, and we may not be on the same team on that sense.
That's not a team. There is no recovery plan when they finally figure out these assets are not worth 55% of perceived value. That's just not going to happen, because every single depositor would take back 55 cents on the dollar right now and not do a recovery plan. That's why this whole thing is a joke, because every single depositor would take their money at 55 cents and be better off. There is nothing going to happen on the recovery.
If they could receive their 55 cents and there was a reorg of equity for the other 45 cents, so they could have a speculative chance, that's better than just the 55 cents.
I'm not disagreeing with that. Yes, that is true. See, watch this, Simon. I can say yes. Yes, you are 100% correct. But when someone comes in right now and says,
David, that's recorded, right, Tone? That's recorded.
I was just with you. I didn't want to interrupt that kumbaya moment. But David and Simon just agreed.
And I managed to get David Silver to sound correct. Unbelievable.
I would tell every one of my clients to take that deal, because I told all of them when these numbers started coming out, if you can get 65 cents on the dollar, that is going to be the best recovery. You guys should grab that, because people didn't want to sign up for the last couple of weeks, and I actually hesitated filing the class action.
David, you also said the SEC was going to win.
Ripple?
Yes.
Yeah, they are. come back to me when that case ends.
They're not going to.
Yeah.
But anyway.
By the way, winning is when Ripple pays the settlement. That's a win for David. Just when we're defining terms on what the bet is. But ultimately, Simon's right. Simon is pitching an idea that allows the retail. By the way, under Simon's plan, my understanding is you basically knock out the equity.
Which
the depositors jump in front of the equity.
1, 2, or 3, David? Which one? 1, 2, or 3?
1, 2, or 3 what?
Of Simon's plan.
Well, I'm just talking about the one he just said.
We're at 3 anyway. We're at 3.
55 cents. 55 cents on the dollar. 45 cents on the reorg, and it moves forward. Equity gets put behind under that plan. By the way, I assume, Simon, equity has to be behind the people getting the 55 cents. Equity has to be below now.
Yeah. So let's just make something clear for everybody that's watching. Simon's suggestion is a plan that he proposes to put forward as part of a creditors committee, hoping that the bankruptcy court will approve that solution over the solution that Celsius is going to put forward. There's no guarantee that Simon's plan will be adopted. He's just talking about alternatives or potential solutions that could be put in place that would be better than that would be a solution that hopefully the bankruptcy court would adopt. So just because there's a suggestion here, just because Simon's saying it, doesn't mean that it's going to happen. That's all still speculative, if you will.
Yeah, and this is why I'm agreeing with Simon, because what Simon's talking about is helping the depositors regain percentages of their money. Simon and I are on the same exact page. The only way, first of all, you can do that is...
He says this. He prefaces this with depositors first, with his 1 and 2, 3 options. So yes, I'm on Simon's team.
We're all on Simon's team. Simon's presenting a huge win for the depositors. The only people who aren't on Simon's team would be equity. Which, by the way, they're going to also...
And ironically, I am equity. And and so that's why I want to put together a future of equity that also tries to make something of that as well.
So something to point out in
guys, I'm gonna take a 5-minute break. I have to go talk to someone who lost 15 million in Celsius. I'll be back
David,
to discuss what
David,
I learned.
David, can you hear me? David,
Yeah.
David, real quick. I wanted to say this all day. Have you seen the live chat? You are now taking over as the most hated lawyer over Jason for now. I just want to read you 2 comments right now before you go. I hope Seth Rogen is wrong. A lot of trust in Simon and his plan. And here's one more. This David guy is enjoying this fade way too much.
Isn't it ironic that the guy who represents victims is the bad guy for telling the truth? I gotta tell you, of all the people I spoke to,
I learned that point blank, David. When you tell the truth, boy, do you get attacked.
Exactly.
That's what's happened to me for years, David. I've only told the truth. You're finally telling the truth, and now you get hated too.
I'm okay. Big shoulders, fat guy.
Right?
I'll be back in like 10, 15 minutes.
So what I was going to talk about with Celsius is that the concept that this product that they had, which was these earning accounts, right? That would somehow continue. It can't continue because if you go and read the New Jersey cease and desist order, Texas, Alabama, and I think as Bell's put out, there's a couple others, that earn rewards program, which is where you put in your cryptocurrency, they hold it, they get to do whatever they want to with it. And as a result of that, every week you get paid out, 7%, which is 1% per day. And if anybody remembers, that was the same deal that the Bitcoin Savings and Trust had with Trend and Shavers. That same identical program was deemed a security by the SEC back in 2014. We have known that this type of lending or type of program has been an investment contract. And all New Jersey did, Texas, Alabama, is reaffirm the SEC v. Shavers case from 2014, which means it's a security. It is an investment contract, right? If Celsius was a bank, it would be a deposit account. You would have banking laws that would come down on top of it. It wouldn't be an investment contract because you'd have the regulation of banking industry that went on top of it. But because Celsius is not a regulated entity, it falls under the standard investment contract analysis. When Celsius refused to acknowledge that earn rewards program was an investment contract per the cease and desist orders, and instead, if you go and look at what they did with their Edgar filings, they did a Reg D filing, which effectively registered the CEL token involved in the rewards program as being the security. They even refused to acknowledge what part of that program was an investment contract. So anything moving forward with Celsius, the earn rewards program can't be a part of it unless it's properly registered and properly administered. Otherwise, whoever continues on is just going to get another cease and desist order. So whatever solution comes out of this for these investors thinking they're going to continue to get their 7% or their 18% or what have you, it's going to have to come in a different form.
Yeah, and that's the 3 things that we're presenting in our plan is that leadership that actually has a track record in this industry of disclosure that has worked under a regulated environment in some of the most regulatory hostile industry. Pristine collateral. It's got to be dollar-backed stable coins where the dollars are convert. You can pull out the dollars if it's in, and Bitcoin. And then full disclosure of risks. Securities laws. We've worked on all of the securities laws and the registrations, and the team that has already been working with the SEC and FINRA for the last 6 years on all of the different registrations you need in order to pull this model. And that's the equity that we want to be proposing to make up the haircut that, Celsius has lost for everybody.
So Simon, let me ask you a quick question.
Simon, is this recent?
No, well, we've been doing securities in Bitcoin for 10 years. We did a mining back security.
I'm sorry, when you say we,
Bank to the Future.
Bank to the Future.
Bank to the Future, yeah, the first securities business in this industry. We've been around since 2010, and most of the major companies in crypto have had a portion of their funding round through us. And we've done lots of securitization. We've been doing this for years quietly. The reason people don't know about us as a big brand like Celsius is because we're very careful with our marketing and we comply with the rules, and we make sure that only investors that understand the risks and those that are actually suitable to invest are the ones that have access to these financial instruments.
So let me just hold on. I need to make a correction. Apparently, I said that Celsius was 7% per week. I didn't mean to say that it was. I know that there was 7% to 19 or whatever percent APR. I was referencing the 7% per week.
The Luna or the Terra stable.
Right. So I apologize if I misspoke. That wasn't my intent, but I see there's people losing their shit in the chat right now. Simon, one of the things that I wanted to ask you is, look, and I don't represent you. I've never represented you. I've never represented one of your companies. We have zero legal affiliation, correct?
Correct.
Great. So what possibility is there for Bank to the Future to go in and make a bid for Celsius in whole as a platform during this bankruptcy, to just buy it outright from the trustee? Not do a Chapter 11 reorg, but push for a complete liquidation for acquisition of all the assets and all the accounts. Have you thought about that?
Yeah, well, I mean, we've got the best legal teams working on the different ways and approaches. And obviously this company, there's no future under the company. So it's only can be putting together, because I'm in this position where I'm a shareholder, a depositor, and somebody that happens to run and operate a business that believes that there's a future vision for new equity. And so therefore I'd like to put all that together to try and make a good result with people that understand the risks. And so we're looking at every strategy, but every time we get, and we're dealing with multiple different types of companies, and they're acting very, very differently. There's a certain set of companies that are acting in one way, and then there's another, Celsius, which is clearly putting every single blocker in of any solution that might make depositors whole in this, because there's one person that is putting together a strategy not for depositors but for his ass.
Simon, what do you think?
Can I ask a stupid question?
Simon, guys, I'm
right,
sorry.
yeah,
Ladies, I'm sorry. Simon, I'm sorry about your father, by the way. My condolences. I hope everything is okay with your family.
Well, it's been a bit of a distraction, so at some stage I'll get back to that.
I'm really sorry, though.
Thank you.
I am. And you're always welcome to come down to St. Lucia whenever you want to. I'm here in St. Lucia, so open invitation. But so you put forward 3 limbs for a plan. And I looked at them. I like the fact that you were taking the power into the community's hands, or you were attempting to do that.
Yeah.
But I know you've had a lot of experience, and we have not worked directly together, but I've heard a lot of great things about you. I've been in the space for 12 years myself. Which one of the limbs do you think would be the best plan to go forward? Because I particularly liked limb 2.
Yeah.
So I wanted to ask that.
Yeah, let me share that journey. So I created a plan which we executed successfully with Bitfinex that led to one of the highest performing investments, even beat Bitcoin in terms of the results that it created. I'm not saying that can happen again. That was just an exceptional amount of execution, luck, and market conditions that made that work. But it relied upon Celsius, believing that there was a future and they weren't covering up all sorts of shit, and full disclosure. So then that went out the window. I then put together a bunch of, in fact, got commitments from up to $6 billion from people that would put together, the liquidity and then an equity offering similar to what might have happened, what happened to BlockFi essentially, following and various different models, but then could involve more people in the equity rather than just making FTX the JP Morgan of crypto. That was blocked because no regulatory transparency and no financial transparency. So then finally we realized the only way to get the transparency needed to have an effective plan. No investor's going to just I mean, there are some crazy investors in crypto that got deep pockets, but you still need the numbers. You need to understand the problem you're solving. So then we move to phase 3, which is there has to be a way to get Alex Mashinsky out of the way, and then we can move forward with the plan. And so now it's all about what is that approach.
And
I want to
like removing Alex and placing you, like doing a takeover effectively.
So that would be right. What's the number? What is left? And do a haircut, and then effectively do a bail-in, but for a new entity that's already ready to go with all the regulations, all the registrations, and a team that are already approved as fit and proper in order to do this.
All right, guys. I'm gonna play moderator. Dallas, I want to play moderator.
I'm sorry, Joan.
Yeah.
I was asking Simon a question. Simon, would you be ready to take on that role to really just to do it?
I'm ready. We've been working on our Bitcoin investment banking licenses for years. We got the securities side for years. We got a broker dealer within our group. We also have a team that have been working with regulators for 6 years on the lending side. Before all this, we were in El Salvador working with the government on figuring out how to put together a Bitcoin-backed bond for in order to have an alternative for the IMF with President Bukele. So we're willing to do that. We've got a vision,
but it's not a. I mean, it's not a badge. The Bitfinex thing is more appealing to me in terms of how likely you are to succeed in recovering this.
Yeah.
Mess.
Yeah, so we were a shareholder in Kraken, and Kraken was part of the recovery structuring for Mt. Gox. We did twice with, firstly with Bitfinex in 2016, and then there was the Tether hole as a result of crypto capital, in order to support a recovery plan there. And we've got an effective recovery plan here, and we do believe that we can do better. Obviously there's all sorts of risks involved in that and lots of things that can go wrong. But we believe that we can do better than what all the other alternatives are. And there's only one person that's in the way of that, and that's Alex Mashinsky.
All right, guys. Okay. So we're approaching our 2-hour time, but I don't mind going longer. But so I want to give Bill a say. Bill has been patiently waiting. He started saying something, never got a chance to say it. So I'm going to give Bill a chance, but then no comments to what Bill says. I'm taking over after that because I want to say something.
Well, I had a couple thoughts, and I haven't chimed in because bankruptcy is really not my bailiwick. But for you, Simon, this restructuring plan is interesting. I think you've answered a lot of the questions I had. But what about the brand? Well, I mean, what's the value?
Yeah, Celsius's brand is over. We'll do this under Bank to the Futures brand.
Right. Okay.
That was actually gonna be my question.
So really, what are you buying? I mean, what's the value of the assets that you'd be buying and bailing in? Is it just the upside on the potential equity from being able to keep it as a going concern and getting that discount back up somehow?
Because I wasn't speaking over, but it cut out a bit. Because I'm in a unique position whereby I'm a depositor, a shareholder, somebody that advocates for the industry and already has a business plan that we were going to be doing this anyway as a Bitcoin investment bank. And we've been working on the licenses for that for a long time. Then I believe that it would be an amazing thing if we could take all of those people that are in complete distress right now and give them some kind of upside in a company. And we can, deluded as I may be, we can champion that we've found a free market solution that was done by the Bitcoin community for the Bitcoin community. I'm one of those deluded people that believe that there's an amazing story that we could do here. And I also believe in karma. And if I could also support a lot of people that are in distress right now and actually give some kind of result to them, and Alex Mashinsky was in the way of that, then I'll fight that till the frickin' end.
So is a lot of this is there customer acquisition strategy here? I mean, basically you would be.
There's a lot of customers that have been hurt.
Right.
We believe that we have the operations, the technology, the regulations, and the brand in order to attempt to win back trust and give a better result for those that are in a distressed situation. And for those that actually believe in the future vision, just like with Bitfinex, benefit from the recovery.
I'm going to step in just for a second. Tone, one of the questions that people had, which was a good question, is how can they sign up to be a part of the unsecured creditors committee? And Tone, I've just put into our Telegram log group a PDF document from the trustee's office that has the information and links on where they can go to fill that out and what form they need to fill out.
I'm gonna pull that up. Hold on.
Yeah. Sorry, and I wanted to do that before I had to go. I'm a little bit past time, but I wanted to provide at least that valuable information for anybody that's watching on how.
All right, I will. I don't have the link to the video description, guys, because this is a PDF document, but here it is on the screen. I'm sure you can Google for this. Just, a couple of things. I'll try to find it online and throw it in the video description. Jason, before you go, I'm gonna take literally 15 seconds, and I really wanted to play this clip when David started speaking about this, of what happens to your money. So if you don't know who this is Trayvon James. I'm sure David Silver knows this name very well, and I really hope the audio comes.
Yes,
I really hope the audio comes through. So just
please tell me it's Trayvon talking about Celsius.
Not Celsius. No, this is an old clip.
This is 2010, isn't it?
Everyone, listen up. You didn't lose your money. Now you have your. Technically, you kind of lost your money. You lost your fiat money, kind of. But there is hope. You can't. This is cryptocurrency, and if there's one thing that people who have been in cryptocurrency for a while know, that you only lose when you sell.
Oh wait, I'm sorry. Shit, I'm not on screen share.
And wait, they will be more than they were when they gave them to you. So $363. So you got your Bitcoin coins at $363. I understand it is a fucked up situation.
I can't believe I didn't have screen share on when this started. I almost want to do it again. When did it start?
You did not lose $30,000. Okay. Everyone, listen up. You didn't lose your money. Now you have your. Technically, you kind of lost your money. You lost your. But there is hope. You can't. This is cryptocurrency, and if there's one thing that people who have been in cryptocurrency for a while know, that you only lose when you sell. If you hold on to your Bitcoin coins and wait,
that's ridiculous.
They will be more than they were when they gave them to you. So.
Oh my God!
That's a classic.
I haven't done this in a while.
But can you notice anything, any overlap here between, for example, the way Trayvon James talks and Alex Mashinsky talks? Is there any lessons for anyone?
Alex Mashinsky is a smooth operator that says, he says the things that really touch the buttons that would take somebody's entire life savings and put them in a high risk hedge fund without no idea.
And it's all upside, right? There's no discussion of risk.
For Simon, I have a question for you.
Yeah.
And it's not about the law. It's not about your restructuring. Nothing like that whatsoever. Was he your friend before this?
No, I keep a lot of friends as in many. I wouldn't say that. No, I didn't really like the way that. It's not a friend. It's not hurt upon that. I was very, very upset that he was willing to allow me to take down pretty much everything I've ever worked for and built, by trying to entrap me in his mess when he knew there was a mess. That upsets me. But no, it's not really that. It's the stories that I was getting from so many people and experiencing what you all must experience when you're involved in these things at a time when I was really emotionally charged, and knowing that I could do something because I'd done it before. And that's really what got me and what keeps me going. And then when I started
what was the sway? What really pulled you? What was the value proposition for Bank to the Future to invest?
There's a business case as well, no doubt. I want my deposit back. I've got shares,
I'm so
and
curious.
Bank to the Future could bring a lot of people along if we succeed.
So
All right, I gotta get back to Jason. We gotta let you go.
Yeah,
and
I just wanted to talk about this letter from the DOJ. All right,
here it is.
If you scroll down a bit, the one thing that it points out is that if you do go back up, Tone, if you do want to be a part of the committee, you have to get this filing in under a week. July 21st, 2022 is the time for that. So if you scroll down, there should be a link for where this questionnaire is. Go down a little bit.
Is this not it right here?
Just so people
No,
know.
that's the email address to where you send the questionnaire.
Yeah. And just so people know, this is mostly predicated on amount of loss.
Right.
So, I'm not saying you shouldn't apply, but know that the chances of you getting it, if you lost less than $1 million, highly unlikely.
But it doesn't hurt to apply. It's kind of like registering to vote, right?
Exactly. I'm not telling people not to do it.
Right.
I'm just giving expectation.
Yeah. So scroll down a little bit, Tone. I think there might be a link at the top of the questionnaire.
Oh wait, there's a lot more pages here. I thought it was just 2 pages because
no,
it kind of ended, but this thing goes on and on and on.
Yeah. So stop there. This is if you scroll up a bit. Okay, I was hoping there was a link to.
There might be. I mean, there's more pages here.
To where this form is.
Is this it?
Yes. Right. It says a copy of the notice may be obtained at the following link. Well, that's the notice of the regulations for that. I apologize for not having the link to it. I received the document as a matter of course and I didn't download it. It was sent to me. But maybe there's a way that Tone, you can figure out how to get that out for folks that want to do that. On that note, I apologize. I do have to bounce. Great talking with everyone. Simon, nice to speak with you again. And for those that are watching and have suffered loss, like David and like Simon, I too have received a lot of contact from folks that have just heartbreaking stories. And what I would suggest to anybody under these circumstances is take care of yourself first. Go and seek some counseling. Go talk to a therapist. When you talk to a lawyer, they're not qualified to be that type of counselor to help you through the emotional aspects of what's going on. We can only talk about what might happen with the law or what could happen or what your rights are. We're not equipped, nor are we good at dealing with the social side of things. So if you've suffered loss, take care of yourself and please be well. And on that note, Tone, thanks very much for the time, and we'll talk again soon. Very good. Thanks.
Yeah.
Cheers,
No. I really wouldn't mind bringing the show back regularly. I just really need a producer. It's it's so hard to organize these things.
I know how.
Hey, Dallas, your audio and video is coming in really badly, and people on the live stream are kind of complaining.
Bro.
I know, but it's hard to understand you, and it's become a little bit of a challenge.
Cheers, everyone. We'll see you later. Bye.
See you, Jason. I also have to dip out and get some actual work done today. I have a
If Simon and
correlate
David
on
can stick
something.
around for a few minutes, because I have questions and our live audience has a lot of questions.
Yeah, I got no problem sticking around. I see the tipping feature has a lot of questions. I'm happy to keep answering questions.
Yeah.
Thanks, everybody. It's been a pleasure.
So you're gonna send me
We'll
you send me a check for the tips, right?
Perfect. Yeah. Jesus.
I need something better than the box wine.
I'll buy you a drink, David.
Doesn't even accept Bitcoin.
Hey
What you
guys,
really want.
I gotta bounce because my reception is so bad. I'm traveling. So I will see you. Bye, Tone. Bye,
Bye,
David.
Del.
Say
I'll
goodbye
see
to
you
the rest
soon.
of us.
I'll swing
Why is it
by
just
St.
by
Lucia.
Bye,
tone?
everybody.
Like we're not real people.
Come to St. Lucia. Come and hang out.
Enjoy. See you, Bill.
You guys.
Bye,
Bye.
Del.
Yeah.
Bye, Del.
Yeah.
All right. Simon, I have a question.
Mhm.
And it's a really simple question. Why do you believe Celsius has a viable business model worth restructuring? Because in that interview in 2019, early 2019, when I basically called out his entire business model because I did not see it as viable, because unlike something like on-chain capital, which is, locking up your Bitcoin and giving you loans at a proper percentage rate, like Mashinsky's entire vision for what he was doing was never it was going to be a Ponzi scheme from the start. So are you like looking to just take control and turn it into something like on-chain capital? Like what is the viable business model here? Because doing this over Ethereum, I mean, like you and I have very different views on anything other than Bitcoin. So I just don't see a viable business model there worth salvaging.
Yeah,
And
well,
creating a
Wait,
proper
can I ask
business.
the question a little bit differently, but the same question?
Yeah.
Is there any value to anything besides the customer list? Because to me, and I think this is kind of what Tone is saying, if you can't replicate the yield, there's no business model. So I understand why the customer list and the support has value, but I don't understand what is restructuring a company who can't replicate the success.
Yeah, so exactly what you said. I'd like to take this situation and try and make the most for a lot of people by turning it into a viable unchained capital business model. Combine securities and debt, you get realistic rates and put together, and only use pristine collateral. And pristine collateral to me is Bitcoin and a stable coin where you can pull out dollars.
I mean, but again, to me, that's why that's why liquidation makes more sense than the reorg, because a reorg is designed for the business to be an ongoing concern.
Yeah, but the liquidation involves taking everyone's crypto assets, selling them, cascading the market, probably exposing more shit in the market, when potentially we could just put an end to this situation. That is the relationships that matter, that mean the most to me.
Again, Simon and I are on the same page, people. Keep getting shocked.
Yeah. If you take, what went wrong with Tone, this as well, but help everyone else understand. You got Bitcoin. The proposition is digital hard sound money. It's challenging to run the business because you've got to factor in volatility. So that requires a good risk management team to factor in that volatility. Then you've got a stable coin where if it depegs, you can actually pull out the dollars. So then you're managing the risk. Is it backed by dollars? Then you go down further and you've got Ethereum where it's proof of work. And they've been saying for 7 years, it's going to be proof of stake. What the hell happens to that? That adds a bunch more risk. Then you have a stable coin that's algorithmic. And then you've got like a central banker that's trying to say that if it all goes wrong, we're going to back it by Bitcoin and then you go further and further down the risk curve, and then you've got a bunch of unlicensed securities.
It's a concept. It's a concept that has been referred to by our friends at Bitcoin Uncensored, and David knows who they are, as turtles all the way down. And you can Google this term, turtles all the way down. Go to images, and you'll see what it means.
Yeah, so it's just layering risks, and there's no risk management team in the world I could liken it to bloody long-term capital management. The smartest people in the room that still managed to blow, the precursor to FDIC up and create a bank run almost. And that's essentially what happens when these platforms are trying to manage that. So let's just take it back to basics. And as I said, we've been working on securities and debt markets for Bitcoin securities for both individuals, companies, and countries. And I'd like to bring it back. And this seems like a good way of turning a really shit situation into something that could be really good.
All right, let's get to some audience questions.
I'm here. I never really left because things were happening.
Loopy.
Things are happening. I'm going to stay. So I did stay. And Simon, what I do like about taking this by the reins is that you're really putting this in the hands of the community. And you're really giving a sort of like fuck you to the regulators in a sense. I think if the company were to file bankruptcy at this point, it would mean that
the company has filed bankruptcy.
Chapter 7 you're referring to, where it liquidates everything.
Yeah.
You can liquidate in 11 also.
I'm sorry, you were not
here.
This
was one of the live questions.
I'm a bit loopy from the dentist.
Yeah, we could tell.
Yes, our live stream audience has been noticing that as well.
Loopy, dentist. There would be a lot of things that would not be disclosed to Grandpa. But what? Why are people laughing? What is going on?
I'm reading the live chat.
What?
I might be Seth Rogen, but I'll take a rich movie star to what's going on now.
Fine. I'll just stop. I'll say bye to everyone. I'll just go. I'll go rest.
Yeah, you're getting. You know how ruthless my live stream audience are. You're getting roasted right now.
No, but you touched it now. I would love for the Bitcoin community, and I would love for a bunch of people that have been completely misrepresented in the shitcoin community to actually learn that there is something viable here and use this as an educational experience. And just do it by the whole community. Show that's what a shit business model looks like. This is what a good business model looks like. Let's do it together. I think that would be cool. And that's what we've always done.
And that's why I love your plans, Simon, because it really just takes into account that, like, look, we're gonna just rally the community. We're gonna create a solution, and we're gonna do this together. I really like this, and I think it really just takes away the onus of the regulator coming down and just deciding something, or the company like actively filing for bankruptcy.
All right. I know I gotta play moderator again, because like I'm already like the live stream. I'm like losing questions. So there was a tipped question, a super chat question about something about Voyager and chapter 7 versus chapter 11. I was trying to read that question, but it has now come off my screen, so I don't remember that question exactly. I'm gonna read another question. Can you discuss the likelihood of clawbacks? I think we covered that a little bit. I mean, if they find out that Mashinsky's cousin took out a bunch of money, they can probably go after that cousin and try to claw that back. But I'm sure in David Silver's experience, that money ain't coming back.
This is going to be such a mess, because people don't appreciate, if you were in Celsius early on, and this is deemed a Ponzi scheme. If I'm going to put the word if in there, if this is deemed a Ponzi scheme, preference actions, clawbacks, you don't get the interest you were paid. So it's cash in versus cash out is what you have. And anything on top of that, this is going to be a nightmare. If this is deemed a Ponzi scheme, it doesn't go through a reorg and goes through a liquidation. The adversarial process, 90-day preference claims coming back if you got money out in the last 90 days. It's going to be an absolute nightmare. But yes, there's a chance of clawbacks, preference actions, you name it. Everyone's on equal footing. So what happened while they were insolvent, I mean, God forbid they were deemed insolvent in July 2021. An aggressive trustee could push back even further. This is a complete nightmare if this actually unravels as a true Ponzi scheme.
All right, one more question from Keith. Appreciate the stream. Can you get David to discuss what he thinks will happen with custodied accounts 180 million, I guess, at this point.
So again,
do you know the story of the custody accounts, David?
I do, but I'll let you go first.
No, so basically, my understanding again is that they got regulatory enforcement action and said you can't offer this. This is an unlicensed security. So their solution was to take all of the US investors, find out which ones were accredited and which ones were non-accredited, and then take all of the non-accredited, the ones where there's the most amount of risk, structure it into a company, and then try and sell that off to try and plug some of the hole, as well as restructure the mining company to sell that to plug some of the hole. But essentially, it's from my understanding, it's just unlicensed custody. Just because you called it custody doesn't mean you got a license to do custody. And custody has serious meanings. And so just by, say, is it siloed through a trust? Does that mean that the customers actually own this? Or was it just called custody as a marketing terminology to try and beat a regulatory issue? So you carry on.
Okay, so Simon kind of nailed it. There are two types of wallets: custodial wallets and non-custodial wallets. If you don't have access to the wallet, it is a custodial wallet and your money is gone. One of the things the terms of service says very clearly. Now, I'm going to move to have the terms of service thrown out, so I don't actually believe what I'm saying here. I'm going to tell you what Celsius's argument's going to be and what the bankruptcy's argument's going to be, is that you pass title and you own none of your crypto the moment you sent it to any wallet of Celsius. So from my perspective, and I think what Simon's saying is accurate, don't look at the term that was used, use at what the function was. If you can't withdraw from a wallet your crypto does not belong to you. In Celsius, it matters even more than most, but the old phrase, not your keys, not your coins, applies here. That's just estate money, not your money. There's no differentiation just because it was called a custodial or non-custodial wallet.
Hey, can I just do a screen share real quick? Because everyone is asking me for the link. Is this it? Is this that same document?
Voluntary period for non-filing. That's the bankruptcy filing. That's not it.
That's not it. Okay,
No.
because I'm looking for it online so I can just throw the link in the live chat or something.
If
you're looking for the link to join the committee,
I'm still not sure what the hell that means, because remember,
okay,
I saw this as a Ponzi scheme in 2019, and I told everyone to stay away from it. Mashinsky always rubbed me the wrong way. But see, my view is different, right? So my view is, here's how I recognize a lot of this garbage, right? It's a very, very simple question. And anyone that messages me, and I get these messages every day, Tone, can you promote my company? I'm still on screen share? I'm just on a Google search. Okay, that's fine. I'll take that out. If you guys can find like a link I can post in the YouTube description or something, that'd be great. So here's how I see the world of crypto. Whenever someone mentions a project to me, I have one question. Does it have a does it have a token whose value is determined by speculative supply and demand on unregulated exchanges? That's it. It's a very, very straightforward, simple question. Is this on CoinMarketCap? Is there some kind of like this is like, is it on the New York Stock Exchange or is it not? If it has a token. And if the answer is yes, we have a token and it's not a stable coin and its value is determined by supply and demand on an unregulated exchange, whether it's Binance, whether it's FTX, whether it's anything, I immediately stay away from the project, because what it tells me is that the people running this project are not in line with my ethics of a legitimate project. Done deal, right? The moment I hear Celsius had a token, it's over. I have zero interest in Celsius. And at this point, if you force me to spend even 15 minutes digging into what their actual business model is, I will show you where it's fucked up, okay? But the answer, yes, to the fact that it has a speculative token, answers so many things for me that I have no reason to even look into the model. So I always stayed away from Celsius, and that's why I didn't know too much about their inner workings because it was totally irrelevant to me. I knew it was going to get screwed up sooner than later. Now, if we look at something like Unchained Capital, for example, which does crypto-backed loans, and by crypto-backed, I literally mean Bitcoin-backed, the question is, do they have a speculative token inside their company? And the answer is no, they don't. Well, because they don't, I am now willing to consider looking at this company because they are aligned with my line of thinking. So that's why it's hard for me to find this document because I'm not sure exactly what I'm looking for. Jason, if you find a link, because I can't put up that PDF file technically. If you find a link to that thing, I would love to put it in my video description.
Yeah, Tone. Sorry, as many of you can tell, I am driving, and I've switched to my Star Wars gear for driving because that's appropriate. I will try to at least get something publishable for everyone on that creditor committee request. One of the things that I wanted to touch on that I heard David say briefly in the ownership of the coin based on the terms of service. On the back end of the terms of service, and I agree, the terms of service should be thrown out. And David's right on that. That there's just so many unconscionable things going on there that they shouldn't be considered enforceable. However, if we are going to take it at the four corners of the terms of service, those contracts, that the transactions are governed under the terms of service, if anybody, to the extent that you send your cryptocurrency to Celsius or did, and you accepted or understood that they could do whatever they wanted to with it the moment that it hit the account, there's also a structure for getting that back. And that was by putting in a demand for the return, which is a withdrawal. And the moment that you insert that demand,
and this is why we don't join with phones from our cars.
I'll tell you what Jason was going to say. If you made a demand to withdraw from Celsius, they had like 24 hours to give you your coins back. So if there's a very small niche group of people who made a demand for the return, then title really belonged to them. So it's an issue of who holds title to the crypto is what Jason's getting at. And that's true. If you're in that small group, that's a good group to be in. It's going to put you ahead of other people.
Hey, David, I'll tell you what's quite interesting about that. So as a director of a regulated company, we have to have any team members that join our company, we have to have a conflict of interest policy. And all of our team and myself, whenever there's a conflict of interest, we have to submit it. And that's inspected by our regulator. We also have to have a whistleblowing policy. And whether those are in place in Celsius, I do not know. But those are requirements for a firm like ours. Now, this created a really interesting and some of the challenges being involved in so many different parts of the industry. If I were to withdraw my funds from Celsius, then in discovery and the position that I'm in, whereas I'm a shareholder, a depositor, and somebody that was going to try and put together a restructuring proposal, it would call massively into question my ethics, my integrity. I would have to probably disclose to all the other shareholders at Bank to the Future why I'm taking that deposit out if I thought it was for a distressed reason. There was no shareholder updates. There was no disclosures on the finances or anything. And so, and people across this whole industry were like, saying, why don't you buy some, sell, or why don't you short some, sell, and stuff like that. And I was just trying to explain to people in this market of zero understanding of what it's like to operate in a regulated environment, that what you do has serious consequences when you're in these types of positions. So even if I wanted to withdraw, I'd have to go through so much bureaucracy just to do that.
I mean, my presumption here is that you did not know about the $500 million hole in July 2021, and that people that there's going to be a limited amount of Celsius insiders who knew about that. Because people, and I want to take Simon out of this, because Simon, just like he said, he's wearing multiple hats with Celsius, which puts him in a very unique position, unlike most unsecured creditors. Most unsecured creditors in Celsius didn't know about the $500 million hole. They didn't know that Mashinsky was taking money out when Mashinsky was making representations that he was not selling Celsius tokens. So for the individual, I mean, and this is why look, I'm obviously very pro regulation. I'm very much pro the SEC. I'm very much pro that, investor protections matter. And this is why, because can you think for a moment, if Mashinsky announced in June of 2021 that there was a $500 million hole in the ledger, and that the SEC requires different statements on liquidity. So if you invest in an illiquid market, you have to literally write it to zero. You cannot use something, say this is liquid versus illiquid. And if they said in June of 2021, that the value of Celsius was negative, nobody would have given money. I mean, this is why, like when people are, in crypto, and look, I think that a lot of people are going to look for the next Celsius. And I think this is where Simon and I diverge. I do think wiping out Celsius, liquidating it, letting the market, by the way, I'm a capitalist free market believer. If it's truly liquidation would drive down the value of Bitcoin, well, that's the price of having a free market economy. This should be liquidated. It should be everyone. I tell everyone the same thing. The best thing that can happen to people who talk to me is they get 55 cents on the dollar and pay me nothing. If I end up getting involved and I end up being part, whether I'm counsel for the creditors committee, I have a class action separate and apart from the bankruptcy going after individuals. If I'm involved and I'm getting paid, the investors are making even less money, because the only way the typical platform user is going to get money back is if there's any validity to the fact that there's 65 cents on the dollar if liquidated today. And I would tell everybody I speak to, that would be a huge win for them to get the 65 cents on the dollar back today. I can't understand why anyone would argue that.
Can we talk about next Celsius for a second? There's been a lot of questions in here about BlockFi. Now, here's why BlockFi was not on the same level to me personally as Celsius, because BlockFi did not have a BlockFi token, right? So to me, the token matters. Whether
it really mattered in this model, Tone. You're so right there. The Celsius blow up was so much bigger because of the token than BlockFi.
And this has been my position in this space.
Tone, just to take one step back on that. The reason why it was a bigger blow up, explain it, is because Mashinsky was selling the Celsius token while on Liquid and Uniswap,
but
and then using corporate assets to pay himself, not disclosing that, which depleted the liquidity of Celsius.
Yeah, and also disclosing that we guarantee this because we got a $2 billion balance sheet. That turned out that was just because it was in the midst of a pump cycle that was being created by those buy walls that were being put up internally, allegedly.
Right.
I do believe that's Mashinsky's biggest problem, by the way.
He's got a lot of problems. More than Jay-Z.
That's true. Sure. But, I mean, I've seen some like 46,000. I've seen like the Arkham report had a couple of things. Like I'm not going to say if he pulled out like less than $100,000 in Celsius tokens, I'm not going to hit him for that. But if it turns out he pulled out 100 million, 200 million, his wife, his brother, his cousin, his next door neighbor pulled out hundreds of millions of dollars, I'm telling you, that's how people go to jail.
But also representing a guarantee of the business. Sorry.
That bar should be a lot lower than hundreds of millions of dollars, David.
It is a lot lower.
Just saying.
Oh my God, Tony, if we go back to when we met, that you just made that statement to me. If we go back 8 years, like what is happening to us?
Yeah, that's the funny thing, right? The Bitfinex hack, that was $72 million. Now that sounds like a bloody rounding error on a DeFi contract.
Well, I do think that that's what people are hoping for in the Celsius recovery token. I think that's a black swan event that Bitcoin went. I mean, the Cripsy case that Tom was talking about, we settled out. Bitcoin was at $500. The best thing we could have done for investors is wait 3 years to give that out, and it would have been 20,000. But I do think that there's a lot of people who believe that. I mean, Mashinsky's selling. I'm going to give you a new token, and the token's going to go up in value, and everyone's going to be fine.
No, he thinks that it's going to be bailed out by the mining operation. So if Bitcoin goes, comes back, but the numbers do not add up. I put people that know how to analyze those numbers. Those numbers do not add up. That is not a viable plan.
So on Mashinsky's, path moving forward, we touched on this, and it's in his declaration that was filed yesterday afternoon. And for those that don't know, you can see all of the bankruptcy filings on strato.com. And I think, Tone, I sent you that link to where folks you can even subscribe to Strato, and they will send you email notifications of when any new filings come out. But I encourage everyone to go and read Mashinsky's declaration. You get 0 cents from the declaration that they're going to do anything different other than attempt to prop up the business through Bitcoin mining. And I find that, problematic from an executive leadership standpoint.
Yeah, Jason, I didn't actually get any messages from you, but yeah, so maybe send it later when you're done driving. I don't do now. But
no, if you look in our Telegram group, Tone, I think I sent a link to the Strato website. But if not, I'll send it later.
I mean, you sent that letter from case.strato.com, but that was it.
Okay, I'll
anyway.
I'll update it later, Tone. Sorry about that.
Yeah, like if I get a link to that, So okay, so I do have that question. That bankruptcy question is back. But real quick on the token, right? So this is why, while BlockFi has equally shitty business model to Celsius, at least like because they didn't have a native token, the amount of potential fraud and the amount of potential legal issues goes up exponentially once you create an unregistered, once you create a token that was not authorized by the SEC, right? Like not only is there a legal issue by creating.
Hold on, Tone. The Cell token, they did a Reg D filing on the Cell token back in 2018.
They did
with their initial offering. I went and checked.
Yeah.
So the Cell token, well, it was actually registered by the UK entity, which was Celsius Network Limited, did that filing.
Yeah, but this is an important point. This is an important point, Tone. A Form D is just simply telling the SEC what you've done or what you're doing. And then saying that was approval from the SEC, and people invested based upon Alex Mashinsky's representation.
I'm aware. I'm fully aware.
And then, if it is a security, it wasn't done via a SAFT model to try and preserve the utility. Then it's got to trade on a security token exchange, if anything. And then, if it's tradable on a security token exchange, you've got to have all the disclosures and representations.
Right.
That's right. So the thing that's confused me. Sorry, go ahead. Go ahead, Tone. My apologies.
Right. Okay, look. Where I was going to is this, right? This is why, like BlockFi, whether I agree with their business model or not, and I don't think it was great, but at least I don't have any problems with that company. Like I know a lot of people give like Peter McCormick shit for having BlockFi as a sponsor. Like I never really did, right? I mean, I don't have a problem with BlockFi, but when you create a crypto token, when you create a company in crypto that involves a token, you now have this Venn diagram with 2 circles. One circle opens you up to regulatory crap, whether now you have to file with the SEC or you don't file with the SEC. Like Like you're adding 50 problems that involve crypto like security regulation. Whether you follow it or ignore it, either way, it's additional issues. Then there is a whole other circle that by creating a token as a utility that has free market ways of identifying its value, kind of like allowing, like Amazon allowing people to buy goods and services with Amazon stock. You now create all kinds of other perverse incentives within your project, from developers, from having motivations based on the token's value, to all kinds of potential fraud from senior leadership not being accountable. So it creates these two independent circles. One is a regulatory problem, and one is like an ethics problem of people involved with your project because it has a token. You avoid both of the, and they have a huge overlap as well, by the way. You avoid all of this by not having a token. And this is why I respect projects that don't have a token. And I stay away from all projects that have a token, because what happened with Celsius is the norm. It's not the exception. Any project that has a token, Binance and FTX included, the fact that they have a token where the entire business was built with the money from the token opens it up to these two problems. FTX is probably in best position to avoid these problems based on their political donations and contributions. But not everyone is as smart as FTX to avoid these problems in the way that they have avoided them up to this point. So this is why I don't go into the inner workings of any of these things that have a token. So that's just my view. Anyway, I got off topic quite a bit.
Sorry, I'm answering questions in the chat.
Perfect. Okay, so we do have a question that came back. So this is, I'm going to read it word for word. It's from Flight Watch. David Silver, judge in Voyager queried if I'm not sure what. Okay, anyway, if
Yes.
Chapter 11 was allowed, since they appear to be a broker, could we petition Celsius judge to deny Chapter 11 and go with 7? I actually don't know what the difference is between 7 and 11, so maybe someone could explain that. And if I don't know, I bet you 90% of my audience doesn't know. So go for it.
Okay, so I'm not a bankruptcy lawyer, and I only work with bankruptcy lawyers. I'm in bankruptcy because I don't understand 90% of it. It's an arcane system, but the most generalized difference between an 11 and a 7 is an 11 is an 11, and there are different types of 11, but in this case, this is what's called a voluntary, i.e. Celsius put themselves into bankruptcy. So they did a voluntary bankruptcy in order to reorganize the business, and it gives them breathing room to reorganize the business. It is my belief that in the next 30 to 60 days, a lot more lawsuits are going to be filed. A lot of work is going to be done in the bankruptcy, and this will no longer be a voluntary 11. It will convert to a liquidating 7, and it will convert, or it will stay in 11, but someone called a trustee will oversee the business and will hire someone to be what's called a corporate monitor, as someone that's independent, a corporate examiner, someone who's independent in the 11 to run the business while it's in bankruptcy. And Mashinsky will not be in control. They will put in an independent board. It's kind of what Simon was talking about. I can give Simon a lot of free advice when we're off the Zoom about what I think he's doing, both really good and somewhat maybe not to be the most helpful for himself. But there's a lot of different ways. But ultimately, bankruptcy is about independent evaluators coming in, not allowing an entity and a person like Mashinsky, who, by the way, can we talk about the fact that, he's anti-regulation, anti-law, and he's using bankruptcy to stave off all these creditors? I mean, if you say you're anti-law and anti-bankrupt, you shouldn't be allowed to use bankruptcy to get out of trouble. And that's assuming he's done nothing wrong except make bad business decisions. There's irony in that. But ultimately, the bankruptcy, the court will put someone in that's independent.
So I have the rare pleasure of doing to David what he does to me all the time. I'm going to explain it in simple terms what David just convoluted the hell out of. All right. The question was, what's the difference between a 7 and 11? All right. 11 is reorganization and the company continues to exist. A 7 is liquidation and the company dies. It's that simple. That's all you needed to know, Tony.
Perfect.
Jason
All right,
makes such
Simon.
a better David, and David makes of a Jason.
All right. Yeah, so someone just informed us in a live chat that FTX is Joe
I
Biden's.
think there was another
biggest
part of the
owner.
question, Tony, you missed, which was the whole if it's classified as a broker, that it goes through a different process than if it's
Right.
bankruptcy.
I intentionally stayed away from
So
that. I have no idea.
Yeah, you're
cut him off.
Restricted to certain things or not, and so I'm going to punt that question.
Yeah, I'll tell you, I'll add to it as well. There's a difference between calling yourself a broker and being registered as a broker. So just because you call yourself a broker doesn't mean you're registered as a broker.
There's no way they were registered as a broker.
Well, exactly, because then it would have been sold as a security, and it wasn't sold
Of
as a
course.
security.
They're not a registered broker to be selling services in the United States.
Yeah, so just
Can't tell
because
you
you
what
call
they're-
yourself a broker, I think that pulls down the whole argument.
Simon, you briefly touched on this earlier. One of the things that has boggled my mind is how the cell token was listed on various exchanges around the world when the cell token was clearly registered through an SEC Reg D offering or exemption from registration, Reg D filing back in 2018. And for those that don't understand the distinguishing factor, when you make a reg filing with the Securities and Exchange Commission, you're effectively admitting to the SEC that your asset is indeed a security, but it's exempt from the type of general registration because it meets certain criteria. And Reg D is generally reserved for those accredited investors that it would be sold to. So the fact that the cell token was listed as exempt from registration, sheer fact they filed with the SEC, submits themselves to the jurisdiction and admits that the cell token is a security. So how did it get listed on all these other exchanges?
Yeah, Jason, that's the right to be suspect because all of those exchanges will require a legal opinion. And it's impossible, back in 2017, there were some lawyers that were willing to write those opinions, but getting recent listings, do you know any lawyers that would write a legal opinion that that's not a security when there's a buy and burn and they did a Form D?
Right. So disclosure, I've written quite a few legal opinions for exchanges for various tokens over the years. And you asked a very interesting question. Do I know any lawyers that would write an opinion that said that a token is a security when is not a security when it clearly is? And unfortunately, I do know of a few lawyers that would do that because they'd rather take the money and do the listing than actually stand up and grow a pair and be that barrier to law that they're supposed to be. And it's those lawyers that I think the SEC went after a few years ago and got after them for not being the rightful gatekeepers in this community. How many years ago was that the SEC put out those subpoenas? It was 2018, was it?
In full disclosure, I have never written an opinion telling someone they can put crypto anywhere because all those opinions were bullshit.
Right. So this brings up a whole other topic, which is gigantic. If they did get clearance to file for cell token to be under regulation Reg D, basically, why in the world would any of the shitcoin casinos list that token? And doesn't that open up like Binance for securities violations of trading a registered security while they're not licensed as a broker dealer to do so?
Well, that's the whole point.
Let me qualify this entire discussion. All right, I am basing what I'm saying the belief that the cell token was filed under Reg D based on the 2018 filing that was submitted by Celsius Networks Limited. That was in conjunction with their ICO, and it's my understanding that cell token is what was sold during that ICO, and that there were certain restrictions on they sold 50 million of the cell tokens, and that there was additional release of cell tokens that was supposed to happen at certain price points. Now, if I'm mistaken, and that ICO cell token is not the same cell token that's being listed, traded, and transacted today, then I apologize. That's my error, but it's my understanding that it's the same asset.
I believe it is the same, yeah.
All right.
And that was, people were crying at me saying, "Oh no, it's compliant, it's regulated. Here's the Form D. Alex told us that this has been signed off by the SEC. The whole thing is regulated. It's completely, legit based upon that." And then I'm trying to say to people, well, that means it can't trade on a crypto exchange. And they're like, well, why would the crypto exchange list it? And you're trying to explain that in Twitter when people think you're a bad actor trying to do a hostile takeover or something, you're gonna have problems.
Yeah, you're in this ridiculous loop. Now, that was from my side, right? So I was calling out the cell token as a an unlicensed, unregistered security, like I always do. And then I was always corrected. No, they are compliant with the security regulation. They are actually a licensed security. Tone, you are wrong. You are lying.
So that's yeah. Anybody that said that they're compliant either doesn't understand what a Reg D is, or was sold a bill of goods to the point to where they don't know what they're talking about. All a Reg D filing says is we are selling an investment contract within the United States, and we're only going to sell it to accredited investors.
Right.
And that was only the cell token. That was just that token. That had nothing to do with the earn rewards program or any of the other things that they were doing. It was just that token.
Guys, I have a hard stop in 3 minutes. I'm just telling you, I'm done in 3.
David, you have to say your final thoughts really quick. Every time you hear the word investment contract on this program, you have to understand that an investment contract is a type of security. So it's a subset of a security. So when you hear investment contract, it literally means security at the least. Okay, David, closing thoughts.
I think people are rushing to judgment. I think that there's going to be a lot of quote unquote lawyering that happens in the next 60 to 90 days. The appointment of the creditors committee and the direction that the creditors committees take is going to be important. The constitution of the creditors committee is going to dictate a lot of how the next year or two plays out for Celsius. Ultimately, bankruptcy is not about the survival of Celsius once it comes out of being a voluntary Celsius-run bankruptcy. The moment, and I believe this will happen sooner than later, the moment Alex is removed from this company, which I put at 45 days or less, probably even quicker than that, but I'll use 45 days as my money point. This moment that happens, things are going to wildly change, because I do believe most people on the creditors committee are going to be unsecured creditors without equity, and they will dictate that they don't care about restructuring. They don't care about helping the people who invested in the company. They only are going to move to get the unsecured platform users as much money back as possible. And they are going to be put in the very, very uncomfortable position of having to explain to the platform users that when people say that 65% of the funds are still available, they're going to have to explain to the world that they're only going to get back 10 to 15 cents on the dollar, and why those numbers don't work out as being true and valid.
And why is that?
Why I can't explain it because I haven't seen the internal books yet. Because I keep telling people this is how I get out of tough conversations with clients. If I'm wrong, then just take the 65 cents. Because if I'm wrong and they liquidate, so that's how I have the cheat when I talk to clients and I talk to the hundreds of and thousands of people I'm talking to. That's my cheat. When they all say to me, before they filed the bankruptcy, the number one response I got was, well, what happens when Celsius miraculously recovers? And this was all just a FUD on Twitter. My answer was, you won't have to pay me, and congratulations. The moment that happens, take all your money out and put it someplace else. Then once they file the bankruptcy, it's now the fear, because most people they don't want to have that come to Jesus moment that they lost most of their money. I hope for their sake, I always tell people, one, I don't want to represent you. I hope you get all your money back. I hope you don't have to hire me. I am a nuclear bomb. I am not a precision surgeon. I have to drop a bomb, destroy everything, and try and collect as much back as possible. So for someone like me to be involved in the Celsius case, I have to drop a nuclear bomb on everything that's Celsius, burn it to the ground, find out where the skeletons are, find out where the money is. The one thing that the blockchain does do really nicely, I don't have to pay a forensic accountant millions of dollars to find out where all of the tokens that went out on different blockchains went. Someone with a simple basic understanding of blockchain can simply download an Excel spreadsheet and tell us where the money is. So ultimately, what I feel is that we're going to see a lot more bad news come out. I do think there's going to be more bad news that is upsetting to creditors, especially unsecured creditors who merely use the earn program. That's just my belief. I hope I'm wrong. But unfortunately, statistically in this space, I've been right more than I've been wrong. Simon, I shot you a chat text message. Take a look at it. Jason, wherever you're going.
Hey,
I hope
David,
I answered the questions I could on the chat. This was new for me. I don't normally do that, but
hey, David,
Simon was doing a great job talking for most people.
Hey, David, I made you a moderator in my YouTube chat. Can you just say something David-ish so that I know I didn't give a scammer ad like moderator?
Did you not see the one where I told someone there was a chance, but it's the same chance as me going home tonight and my wife saying I'm good looking and jump my bones?
I've met your wife. She's a lovely woman. She loves you very much.
And all right, Brad, hey guys, G, I just said thanks everybody. So see if that was me. And Brad G, that's why we need Simon's plan. That's simply, again, I agree. Simon's plan would be great for everybody, but
all right. And we're gonna close this out. I'm gonna let Simon, Jason, and Simon. I'm gonna let Simon go last, so maybe I'll have Jason close us out next. I've been doing it for 3 hours. My family went fishing. They just came back with a bunch of fish, and it's now my job to marinate it and then grill it. So we do have to wrap this up. Jason, closing thoughts, and then we'll give it up to Simon.
Sure. So, I'd already given my closing thoughts before, and, as I was going to this thing that I have to do right now, I was listening in, and I agree with a few of the things that David said, that, over the next couple of weeks, there's going to be a lot of people prognosticating about what they think is or should happen. And there's going to be a lot of outrage when things don't go the way that they thought they would go. So to that, I would say just practice a little patience. The bankruptcy courts are quite adept at getting through these things. This is not the most complex bankruptcy that the Southern District of New York has seen. I have every confidence that the judge is going to be able to parse through the issues and will absolutely take into account the messages and the words of the creditors committee. And so I do agree that the folks that do participate on the creditors committee are going to have a pretty big role to play. And I would just hope that when they're putting forward their recommendations, that they consider the 300,000 people that are impacted by this, and not just the few that are on the committee and try to do the holistic approach. And so that would be my appeal to humanity for the creditors committee. And with that, I'll close and say thank you very much. Tone, Simon, you guys know how to get in touch with me if you have any follow-up questions or concerns. And with that, I'll say good afternoon, good evening, and goodbye.
Later, Jason. You're muted, Simon.
All right, is that good?
Yep.
Yeah. Yeah, so my final words is when this all came out, I was invited by Alex to be a board member. That is when I really started to question, you know, what he was willing to do in order to save his ass, but it's not really surprising. You know, I thought it was more useful to not be a board member and not sign the NDAs that would put the, you know, move this in a wrong direction, I think. At the same time, I believe that it's not in everyone's best interest for me to join the creditor committee as well, because I think that I can put a better result for people, or what I believe to be a better result, highly speculative, of course. But you know, the lawyers will figure out how to get you the haircut. And we would like to put together a proposal that would try and give someone a speculative shot at upside, and we've done it before. So I encourage everyone to check out some of the videos. I've been putting them on my YouTube channel, Simon Dixon. Follow me on Twitter, and I'll keep going until I have to sign that critical NDA, at which point I'll have to be silent. Yeah, it's a very upsetting case. It's a lot of people have got hurt. You know, the only thing that I think people can come from this is that there is a business model. Unchained Capital has shown there is a business model. And we've been doing securities for over a decade now in this industry. And I believe that you can combine debt and equity to create a Bitcoin investment bank. And I believe that if we could do that with the entire community and give them some potential upside, if we can make the most out of this shit, then that would be a really cool story to follow. And I've got a team, the lawyers that are representing us right now. They've been involved in Madoff, they've been involved in Lehman, they've been involved in Mt. Gox, and we got a team that will, you know, of the best that money can buy in order to attempt to do this. And there is only one thing in the way of making it happen, and that is Alex Majinsky trying to protect his own arse. And that is the reality of the situation today.
All right. And on that note, guys, thank you so much for watching. All the links are in the video description. All the panelists that were here, their links are there. Or everything I've shown on the screen, except for that Trayvon James, your money's gone video. Everything else is in the video description. That should also probably be in my list of honorable mentions. Hopefully either Mel, who's one of our moderators, or Jason can send me a link to that form. I'm still kind of clueless as to what that form is that everyone seems to want, because I was not involved in this mess. I stayed away from it. This is also why, you know, hey, high risk, high reward, right? Like, people get involved in this stuff and they become very wealthy, and people like myself have to live in the woods because you know, you take on lower risk, you get a lot lower reward. So that's why I'm still not sure exactly what that paper is, or why everybody wants it. But if I get my hands on a link to that, I'll put it in the video description.
You're also not in prison, Tane.
I'm sorry, say
you're in the woods and not, well, you're in the woods and not in prison.
That's true. I do try to stay away from that as well. But thank you so much for watching. This has been a great episode. We'll try to bring you another one of these the next time there's a blow up in the crypto space, which is going to be happening more often. Simon, come on. Okay, on a side note,
Yeah.
is this your fourth bear market in Bitcoin?
Yeah, I've been through them all. So yeah.
You've been through them all, right? So this is my third. This is by far the most brutal, damaging mentally and economically, even though, and it's a big question, even though we only fell, what, 65% instead of the usual 80 or 90. And I was trying to rationalize it, and I'm rationalizing it from two perspectives. One is that unlike the prior bear markets, which had exponential rises, making you mentally ready for a potential overshoot to the downside. That didn't happen this time. We had this double top, and all signs were pointing to more upside. And because of that, people ended up in very unadvantageous positions with their allocations. That's reason number one. Reason number two is that because the overall market cap of Bitcoin has gone up so much, and a lot more people have been there through the ups and downs, this was the time coming out, and especially with the COVID lockdowns and Bitcoin recovering so nicely from the COVID lockdowns and people getting stuck at home. So many crypto people with some wealth started businesses. And now even a 50% correction is more damaging to them than a 90% correction, because now it's just like you can hold through it. Your businesses need to be, functioning. Meanwhile, everyone is in a recession. Nobody wants to pay for whatever your business does. So I think those two reasons have made this by far the most depressing bear market of them all, and it's not even close. Your thoughts on that?
So $30 to $3 was catastrophic, but none of us were trying to make money. We were all trying to take on the banks. And we were all trying to code, and that was it. And so we were just, none of us believed that this was really going to succeed. It was just a long shot. And so that was that one. $1,250 to $250 as a result of Mt. Gox. That was brutal. That was holy shit. Bitcoin's over, because of so many people losing their money, and such bad. Bitcoin was so vulnerable then. They were trying to take down Silk Road. They were trying to say it's just for drug dealers, but it got through that one. 20,000.
And also, but Simon, at the end of that one, Bitcoin was super cheap. That even if you got kind of ruined, you can make an extra $5. I don't care what you do. You can go and shine shoes, and you can still buy a Bitcoin at the end of the week.
Yeah.
If you believe in it.
$20,000 to $3,000 was just, right, okay, so all of these ICOs are going to be securities, and let's get back to building. And then that was just that long, I just like the building phases. I like those sideways markets. This one for me, I do find it less painful actually, but the bit that really, because the conviction and the progress, both institutional, corporate, and individual, and the strength of Bitcoin in terms of compared to everything else, and then everybody learning the cold hard lesson that they learn in every cycle, about all these speculation becoming securities in the end. But you are right. The difference with this one is that there's a lot of geopolitical uncertainty in terms of is there going to be a war? Isn't there going to be a war? There's hyperinflation, and there's just a tremendous amount of financial anxiety, just in the outside of Bitcoin world. And so when you have that double whammy of severe financial anxiety for people in the traditional world, combined with putting all your money in Celsius and there's your nest egg, based upon a promise when you really thought, that's catastrophic. And that's kind of why, if the end result of this is that we end up buying some cheaper Bitcoin as a result of people losing their savings, I'd like to try and prevent that happening if we can. And that's why, to try and do this. But yeah, I guess it's a bit challenging because on the $30 to $3, I was broke. And then on the other cycles, I was fairly wealthy. And this time I've protected myself to be in a financial position where I'm less volatile to, blowing up all my money at Celsius and stuff like that. So I don't think my emotions are reflective of how everyone else will be feeling, because I've just been preparing for this all my life.
Yeah, thanks for that, Simon. Guys, I'm gonna do a price stream tomorrow. I just wanted to glance at the price of Bitcoin. I haven't looked at it all day. We bounced right off the bottom of this channel. and we are still in this channel. I hope we can break out, but the last time we were in a channel, we broke down, and the probability is slightly higher that we will break down one more time. But I mean, there's always hope that it's going to break to the upside. I'd say there is a 40-60% chance we're going to break down versus breaking up, but 40% versus 60 is not bad. It's you still got a good shot at it.
Yeah,
All right.
I think that price is also affected by the fundamentals of what happens with Celsius. So if we've got liquidations, we've got liquidations. If we don't and we have a solution, then yeah, that's the fundamentals, the technicals are gonna tell that story.
All right, guys. So on this note, we're gonna go ahead and call it a day. Thank you so much, Simon. Thanks for joining me. Hope you had a good time on the show. And let's chat soon, man.
Okay, see you soon, Tane. Bye-bye.
Later, Simon. Bye, guys. Man, I'm tired. It's been a long day. All right, time to go grill some fish. Oh, I grilled such ridiculous steaks yesterday. Totally forgot to take a picture. The Financial Summit, guys, please follow me on Instagram. That's where I do like food stories. And also on follow the Financial Summit on Instagram as well. We're still gonna give away 1 or 2 spots to the Financial Summit. Can't cover your flight, but if you can get there, but we're looking for good financial professionals to impress all the other financial professionals at the event. Talk to you all on the next one. Bye, guys.